Please be seated. Judicial Committee of the Highwood Congregation of Jehovah's Witnesses versus Randy Wall. David M. Ganam and Jaden McEwen for the appellant, Judicial Committee of the Highwood Congregation. Shahzad Siddiqui for the intervener, Canadian Muslim Lawyers Association. Barry W. Busey and Philip A.S. Milley for the intervener, Canadian Council of Christian Charities. John Sakima and Andre Schutten for the intervener, Association for Reformed Political Action Canada. Mark Gelowitz and Karen Sachar for the intervener, Canadian Constitution Foundation. Albertos Polizagopoulos for the intervener, Evangelical Fellowship of Canada et al. Derek Ross and Dina Warren for the intervener, Christian Legal Fellowship. Valpreet Singh Boparai and Avnish Nanda for the intervener, World Sikh Organization of Canada. Gerald Chipur QC and Jonathan Martin for the intervener, Seventh-day Adventist Church in Canada. Jay Cameron for the intervener, Justice Centre for Constitutional Freedoms. Roy Millen for the intervener, British Columbia Civil Liberties Association. Michael A. Feder, Robin Gifford for the respondent. Randy Wall. We'll begin with you, Mr. Graham.
Chief Justice, Justices of the Court, good morning. This appeal is about the limits of judicial review. The compelling question in this case is, when is a religious membership decision justiciable? The appellant's position is that religious doctrine, including their process, is not justiciable. To decide this case, appellants submit that this court must first look at the decision maker and then look at the effect of the decision. If the decision maker is a private voluntary association, as in this case, not a public decision maker, the court door to judicial review is closed. But two other doors may open depending on the effect of the decision.
Excuse me to interrupt you at this time, but is it your submission that there is only one set of rules in judicial review, one for any private organizations, whether it's religious or not, or is there, into your submission, a different set of rules, different scheme for religious organization?
Our submission, Justice Wagner, is judicial review is limited to public decision makers. And the congregation, Highwood Congregation, is not a public decision maker, it's a private body. And as the Court of Appeal in Alberta found in Knox, there are private remedies that would be appropriate in that circumstance. Private law would apply. And just if I can just add, excuse me, Justice Brown, I would just add, Justice Gascon, that Justice Wagner, that the congregation does not believe that they're above the law, that just because they are a religious organization, the law does not apply to them.
I wonder if you're stating the issue a little bit too generally. I wonder if there are really two issues here: is whether judicial review applies. And I understand your submissions from having read the factum that you're not a public actor. There's no contractual or property right at stake here. There's no statute. There's no agreement. So no judicial review. That's how I essentially understand the tenor of your submissions. But then there's a second question that even if it were judicially reviewable, is the question of the validity of the expulsion of Mr. Wall from the congregation justiciable. Is that a more correct characterization, or is it really, does it fall under the rubric of judicial review?
What you enunciate, Justice Brown, is the respondent's position, that there is some kind of a procedural review, a jurisdiction under an implied contract, in which case the court would have jurisdiction to review the decision of any private voluntary organization.
But I wondered if your position prevailed, if they didn't succeed on the point of this procedural review notion, that would you then plant your flag and say, well, it's still not a justiciable question? Is that a distinct question from the judicial reviewability of the matter?
Yes, it is.
Okay,
Justice
thank you.
Brown. I agree. And the reason being that this is a religious organization and the decision is a religious one. That's what makes this particular decision not justiciable, falling out of the judicial review regime in place to review decisions of public decision makers.
Okay, thank you.
And then perhaps that brings me then to exactly, just maybe to summarize and come back, Justice Brown. So, as I mentioned, it's not judicial review. That door is closed. But there are two other doors that would be open. One would be the statute. If, for example, the voluntary organization was incorporated under the Canada Not-for-Profit Corporations Act, that statute, the corporate statutes across Canada, would open the court door to statutory remedies and a procedure in place for the decision or whatever might be impugned at the corporate level to be reviewed. And the second court door that opens is the private law remedy based on property and civil rights. And if there's a property or a civil right in play, a contractual right, whether it be an implied contract or a written agreement, that would be the opportunity for the court to review those kinds of decisions. Respondent says that there's a third door to the court, and he calls that procedural review. In his factum at paragraph 23, he says that procedural review is not the public law remedy of judicial review. At paragraph 33, he says it does not engage the Superior Court's supervisory jurisdiction. He argues that it's a question of private law based on implied contract. And before the court for the first time, the respondent says Mr. Wallace never sought judicial review or otherwise asserted that the congregation is a public entity. That's in the reply factum, paragraph 2. And he concedes that the congregation and the Judicial Committee are not public decision makers as defined by the Court of Appeal in Knox at paragraph 30 of his factum. This position is inconsistent with Mr. Wall's position at the start. In his pleadings, he filed an originating application for judicial review under Rule 3.15 of the Alberta Rules of Court, the rule which is providing exclusively for judicial review. In my condensed book at tab 20, the rules are there for you for the benefit of the court. As Justice Wakeling pointed out at footnote 38 of his dissent, the respondent is limited by his pleading. He defined the parameters of this dispute in terms of judicial review.
I must say, I for one would find it difficult to have this case determined on the particular manner in which Mr. Wall framed this, being a self-represented person, if there has been an opportunity for your client to fully respond to the issues that are now before the court.
Justice Roy, I would point out that Mr. Wall admitted before Justice Wilson that he was assisted by a lawyer in drafting his pleading. That's in the transcript, page 78 of the record, lines 20 to 26. But the congregation, in response to the originating application for judicial review, the congregation replied and asked the court to bifurcate the proceeding, to consider the issue of whether or not judicial review, that remedy, that public law remedy, applied to the congregation. And it's on that basis that this matter is before you this morning, is on the question of jurisdiction for judicial review. The respondent appears to agree with the appellants that the Court of Appeal erred when the majority held the Court of Queen's Bench has jurisdiction to hear the respondent's application for judicial review. That's the Court of Appeal judgment at paragraph 29, and erred when it held that judicial review extends to any decision of a private religious community when a breach of rules of natural justice is alleged, paragraph 22 of the judgment. And I repeat, judicial review is limited to public decision makers. This is the unanimous holding of the Alberta Court of Appeal in both Knox and Boucher, and the holding of this honorable court in Dunsmuir and Telezone. As Justice Wakeling stated succinctly at paragraph 75 of his judgment, this ends the inquiry. Appellants agree. This honorable court said in Telezone at paragraph 26, the focus of judicial review is to quash invalid government decisions, not the membership decision of a small, unincorporated religious congregation. The facts that bring this matter to you are straightforward. Mr. Wall was one of Jehovah's Witnesses for over 30 years. He was baptized, or he became a member, when he was 20 years old. He confessed that he was verbally abusing his wife and sons to two local elders who provided scriptural counsel. Mr. Wall knew that such disgraceful conduct is not tolerated by Jehovah's Witnesses. But the problem persisted, and Mr. Wall again confessed to two occasions of drunkenness, one in which he was hospitalized. A committee of 4 elders met with him with the goal of spiritual restoration. They wanted to have him repent from his sins. As the meeting progressed with Mr. Wall, the elders came to the decision that Mr. Wall was not sufficiently repentant for his disgraceful conduct, and the congregation elders took the decision to disfellowship him. That word is used by Jehovah's Witnesses. Jehovah's Witnesses don't use the word shun or shunning. They refer to it as disfellowship, disfellowshipping, disfellowshipped, because that really gives the sense of what's taking place within this particular religious community. Disfellowship literally means no further spiritual fellowship with the individual. And as I point out, sorry, Chief Justice, as I point out at paragraph 22 of my factum, the nature of the relationship then of a disfellowship person is not completely shunned. The disfellowship person is able to come into the congregation, to the congregation meetings. They're able to attend in the Kingdom Hall of Jehovah's Witnesses. They're able to sit wherever they like. They can sing the spiritual songs with the congregation. As far as their family members are concerned, normal family relations continue with the exception of spiritual fellowship. And the door is not closed to Mr. Wall either. The person who is disfellowshipped can, after a period of time, ask to be reinstated in the congregation, because that's the purpose of the discipline. But as I repeat to what Justice Wagner had asked earlier, the appellant's position is that they're not above the law and that its decisions are never reviewable. In Telezone, this court pointed to contract, tort, and other causes of action which are primarily designed to right private wrongs with compensation or other forms of relief, at paragraph 24 of that judgment. That's a whole armament of remedies for Mr. Wall if he's genuinely harmed in a legal way.
Is there not I mean, you've said to us that judicial review, as it is normally used, applies to the actions of the state or its institutions. I don't think that's a particularly controversial proposition. Is there not, however, a separate line of cases which, in which the Hutterian decision, Lakeside Colony of Hutterian Brethren, 1992, this court, which says that in certain circumstances there is a kind of a review, which is not a review of state action, but is a review of the procedures of a private organization, which the court can undertake in limited circumstances. It's essentially a separate category. And just to read what I think is a very significant passage, just one sentence from the majority decision of Justice Gontier. If the defendants, the two members of the Hutterite community who had been basically expelled have a right to stay within the community. The question is not so much whether this is a property right or a contractual right. Implicit in that, I think, is the idea that if there is a property right or a contractual right which is engaged, that triggers the court's engaging on it, receiving it and considering it, but whether it is of sufficient importance to deserve the intervention of the court and whether the remedy sought is susceptible of enforcement by the court. And then he gives certain historical examples and then proceeds on to the particular facts of that case. But isn't it quite clear from this case, the Hutterian case and others, that there is a separate line of cases and a separate basis upon which the courts will, in limited circumstances, look into the procedures by which a private organization will basically end the membership of one of its members?
Justice Rowe, the appellants agree with you. If we look at Lakeside Colony, you were referring to paragraph 9 in the judgment. I have it in our condensed book at tab 13. And I would invite the court please to turn with me because it is a key decision here before you this morning. So tab 13 of the condensed book. And Justice Rowe, you were quoting from paragraph 9. I would just start a little bit earlier in Justice Gontiér's decision at paragraph 6. And at paragraph 6, he points out the courts, the courts are slow to exercise jurisdiction over the question of membership in a voluntary association, especially a religious one. So Justice Gontier basically said it's a yellow light. We're slow, we're cautious. If it's a membership decision in a voluntary association, we need to be cautious. And then he adds, of course, especially a religious one. But then he continues, exactly, Justice Rowe, as you're mentioning, however, the courts have exercised jurisdiction where a property or civil right turns on the question of membership. So there's where the court door opens. It's cautious, yellow light, but it turns green if there is a property or civil right that turns on the question of membership. And as you pointed out, Justice Rowe, at paragraph 9, Justice Gontier adds to property or civil right also the idea that the remedy must be susceptible of enforcement by the court. So as you pointed out, Justice Rowe, in Lakeside Colony, the light turned green. There was both a property and a contractual right. At paragraph 7, Justice Gontier mentions that from the standpoint of the colony, it was a property right. In paragraph 8, from the standpoint of the Hofer family, it was a contractual right to stay on the property. And now to examine again, Justice Rowe, the words that you quoted, I would like to just point out a very important distinction. So just going back over those words, the first sentence of paragraph 9. If the defendants have a right to stay, the question is not so much whether that's the right to stay on the property, is a property right or a contractual right, but whether it is of sufficient importance to deserve the intervention of the court. So the sufficient importance relates not to the question of membership. The it is not a question of membership. The it is the right to stay on the property, the effect of the decision.
So it's not a third category warranting judicial review. It's simply the amber light manifesting itself by saying the fact that you have a contractual right or a proprietary right doesn't necessarily get you through the door. It has to be of sufficient importance.
Exactly, Justice Brown. That's the applicant's position.
Thank you.
And so in this case, as I mentioned, it was a green light. The court proceeded, but I remind the court it was not judicial review. It was a private remedy, a remedy based in contract and property. So with this green light, the court began examining the rules of the colony At paragraph 13, it mentions the starting point was the written documents, the Constitution, the Articles of Association, which were true legal documents with an intention to be legally enforceable. The facts are that within the Lakeside Colony, the adult male members, signed the Articles of Association. There was something very explicit for the court to examine. But then they found, as they started their examination, that they had to start looking not just at the written documents, but the unwritten tradition and custom of the Hutterites. Justice Gonsi described this use of tradition and custom as a vexing question at paragraph 61, and said at paragraph 64, quoting from Professor Chaffee, really one reason to avoid assuming jurisdiction in the first place. The dissent by the Chief Justice, Madam Justice McLaughlin at the time, as she then was, illustrates the difficulty in applying secular concepts like natural justice in a community where the fundamental religious tenet is one of peaceful submission. Particularly, as Justice McLaughlin, the Chief Justice now, pointed out, when the fundamental divergence between the parties was religious values. In this case, the fundamental divergence between the parties is the question of repentance, whether or not Mr. Wall was repentant. Now, Lakeside, as Justice Wakeling pointed out, Lakeside Colony was decided without any reference to the Charter. He points out that both of the parties came to the court. They wanted the court to resolve their dispute. Following the decision of this court in Lakeside Colony was the court's decision in Syndicate Northcrest in Amsterdam. And it's our submission that the principles that are enunciated in Amsterdam would have, at the very least, closed the door in Lakeside Colony to the investigation into tradition and custom of the colony. In Amsterdam, if I can turn the court to that also important decision, it's at tab 19 of our condensed book. It's tab 19, paragraph 50. The statement really resounds in the context of Lakeside Colony. In my view, the state is in no position to be, nor should it become, the arbiter of religious dogma. Accordingly, courts should avoid judicially interpreting and thus determining, either explicitly or implicitly, the content of a subjective understanding of religious requirement, obligation, precept, commandment, custom, or ritual. So it was when they had legal documents with the intention to form legal relationships, the court was on solid foundation. They could apply neutral principles of law. But when they started getting into the custom and tradition, the religious beliefs and practices of the Lakeside Colony, then it became a vexing question.
Can I ask you if we're in danger here? I appreciate that you want to give us context and an understanding of what the religious background is and the cases that say when a court can exercise jurisdiction. Are we in danger of mixing up the concepts of jurisdiction and justiciability? Because when I look at the application for judicial review, it is strictly about principles of natural justice and the duty to be fair. There's no mention of religion. There's no mention of doctrine. So the first question, it seems to me, is there jurisdiction, which you started to address? The next question, if we're not satisfied on the question of jurisdiction, is the question of justiciability, which goes to the nature of the claim again, and that's where religious doctrine comes in. I thought Mr. Wall's argument was there's a property interest here, and therefore, assuming there's jurisdiction, he brings himself within the Lakeside contractual property rights ambit of justiciability. Am I missing something? It just seems that we're blurring all the concepts by focusing on religious doctrine, and I don't see a word about religion except the reference to the Watchtower guidelines at the very end, but it all goes to procedural fairness arguments.
So Justice Albella, in response, the property or civil remedy or interest right that was pled by Mr. Wall was his loss of customers. There was not a property right. He pleads only that because of the decision by the congregation to disfellowship him, that he lost business from his fellow members of the congregation. It's our submission that there is no right to customers. That is not a civil right that would open the door to the review which is proposed in Lakeside Colony. So on the question of jurisdiction, that's where we say the door is closed. But then, as you point out, there is a further question, and it's a very interesting one that raises the issue of justiciability. If we're just talking about natural justice, does that raise a religious issue? Basically, from the court's perspective, why can't we just look at your process, your rules, and assess them just from the standpoint of natural justice? But the answer to that is that the congregation doesn't have rules. The congregation has religious beliefs and practices. That the process that was used to disfellowship Mr. Wall was permeated with religious doctrine. That from the start it begins, when Mr. Wall met with the elders, according to all of the information before the court, the process starts with prayer. Then after prayer, the elders use scriptures. They try and bring the person to repentance. And then they are assessing repentance according to scriptural commandments. And they make a decision about the person's membership only within the religious community, whether or not he continues to be one of Jehovah's Witnesses. So to take natural justice, the secular concept of natural justice, and say, now that must apply to all religious organizations.
Well, let me give you an example that obviously combines theological elements and ordinary contract law. A congregation says it's very unhappy with its clergyman, clergy person, and says, you're fired. It's over, get out. And the reason you're being let go is because you've lapsed somehow in your faith. Obviously, the triggering event is the formation, by the view of the Board of Elders or whoever, that this person is no longer a true adherent. But the consequence is that they've lost their employment. I mean, does not that individual have a right to come to court and say, you know, I've been treated unfairly?
Yes, they do, Justice Rowe. That's the essence of the decision in Lakeside Colony. If there was an employment contract, if the minister had an employment contract and that was being breached by the way in which he was dismissed, or the lack of notice, or the lack of payment in lieu of notice, then he has the right to come to court. And that's perhaps an example from the Ontario Court of Appeal in Hart, where they're looking at that very similar situation, where they said, this is a minister, but what's the nature of the relationship between the minister and the church? And if it's contractual, under the canon law of the Catholic Church, there's a possibility to go to court, but there are also internal remedies within the church. And so the Court of Appeal said those must be exhausted first, and within the canon law, it's a possibility for the parties to come to court.
But Justice Rowe's question exposes a tension, does it not, between the idea in Amselem of courts steering clear of doctrinal disputes and the idea expressed in Lakeside that where it's a contractual dispute, the court can enter into it because sometimes the root of the contractual dispute is a question of doctrine.
It's the last part of your question, Justice Brown, which is the problem, I would suggest. When the court applies neutral principles of law, and so when there's agreements, I think Brucker is perhaps the best example. In Brucker, the court referred to it as it had religious character, religious elements.
Right. But the issue in Bruker was whether I can't remember who was Bruker and who was Markovitz, but whether the husband, the soon-to-be ex-husband, was obliged to get a get, right, to procure a divorce from Jewish religious authorities. It's a nice, clean question in that sense. But what if the issue is, well, we terminated him for cause, and the cause was he wasn't sufficiently adhering to a particular biblical prescription, and that's a doctrinal determination of our authorities. So I guess my point, just flowing from Justice Rowe's question, is that it does get the court into what Absalom says it should try to avoid.
And I would agree,
Yeah.
Justice Brown, that this court has already determined in Absalom that religious doctrine is not justiciable. And so if there is, like in Bruker, there was an explicit legal contract, an agreement negotiated between the parties, the facts in Bruker, an agreement negotiated between the parties with the assistance of lawyers, with the intent to have legal effect. There's a religious element, a religious character, but the decision of the court was not to tell Mr. Markowitz, give the get. He ultimately had. It was the damage was being awarded for the period that he had not done so. But it was a question of damages. It was a civil remedy. And that's the solid foundation for the court. That's the solid foundation for any court. They're not adjudicating religious issues. If you remember, the background to Bruker and Markowitz was that there was days of evidence before the court, competing rabbis, and same in Absalom itself as well, whether or not the sukkah was a required element of the religious practice of this particular group of religious individuals. So, and the court says, that's exactly what we want to avoid. And that's what we say they should continue to avoid. And that's what is happening in this particular circumstance. The congregation's process to review membership is completely religious. You can't pull one loose thread because the whole sweater is going to unravel. If, for example, the court said, well, you do give notice, you want to be fair. In our factum, we tell you exactly how the congregation believes that it's being fair, because Jehovah's Witnesses are reasonable people, and they want the court to know that they're reasonable people and they're fair. But they're not fair because of secular standards of natural justice. They're fair because that's their religious belief. It's their belief that their God, Jehovah, is a God of justice, that he's a fair God. They should be fair. In fact, in our factum, we mentioned that when the elders are judging, they follow the prescription from Moses to judge with righteousness. That's a different standard than judges of secular courts, because they're dealing with religious matters. And thank you, Chief Justice. The matter is just permeated with religious belief. That you can't just pull the one thread and say notice. Lakeside Colony is the perfect example. Once again, they thought, well, the question boiled down to, did the colony give sufficient notice to the Hofer family? And there's pages and pages of judgment all about, was the notice. It's a concept that as lawyers and as judges, we think that's pretty simple. You got notice or you didn't get notice. If you showed up or you didn't show up, there's the answer. But in Hofer, it became a real difficulty. And they had to go beyond the written documents to the custom and tradition, the religious practices of the community. And as Justice Gunty said, that's a vexing problem. And now the court has said, this court has said in Absalom, we don't go there. Religion, tradition, customs, that's, to use the expression from Absalom, forbidden domain.
So you say here that judicial review is not available, but is it your position that an association like the one you represent is immune from liability if, for instance, during the process of deciding to keep or not a member, let's say you say that you're fair but let's take an example where there would be no notice or no hearing given to the person, and then the decision is the disfellowship, and this has an impact on the reputation of the person. So would you say that the association is immune of liability? Forget the judicial review for a moment.
No, we're not saying that we would be immune from liability, Justice Cote. If defamation had occurred, for example, a defamation action could be brought. And in this particular case, as the Court of Appeal was aware, Mr. Wall did bring an action for defamation, but later discontinued it.
Okay.
So there are those remedies. Property and civil rights are available, but it has to be a property or civil right, not just I'm aggrieved because I've lost my friends, or I've lost business. If the court says that's a significant enough interest, it opens the door farther than it's ever been opened. This court has very carefully tried to maintain the limits on those kind of interventions by the court. I would just remind the court, for example, of what it said in Freeman Smith. That in Freeman Smith, Justice Wilson said there's no generalized tort of wrongful interference with another's relationships. And Justice, remembering in Freeman Smith, of course, it was about the estrangement between a father and his children. And Justice Laforêt said for the majority that even those relationships between parents and children have deep human and social importance. The law provides them with no specific protection. And the same thing with regards to economic interests. In Bram Enterprises at paragraph 30, this court said, the law has never recognized a sweeping right to protection from economic harm. So although for certain Mr. Wall has lost clients, members of the congregation, as long as he's disfellowshipped, would not normally turn to them. That's their personal decision that they make based on their religious conscience. But as Justice Wilson pointed out, that's to be expected. But then that's what Mr. Wall expected when he joined Jehovah's Witnesses at 20 years of age. He knew that it's that kind of community, and that's how they identify themselves. And that's how we get into not just freedom of religion, but also freedom of association and the protected right under the Charter of Section 2D, is that it's the way the group has defined themselves that's so important. And that this court, in its jurisprudence on both freedom of religion and freedom of association, has talked about the need for the court to be judicially neutral and a zone of autonomy. And that zone of autonomy, which resounds in both Section 2A and Section 2D, is so very dear to religious organizations. It's the way they define themselves. I just remind the court why we say in Highwood congregation there is no contract. Because for Jehovah's Witnesses, the belief is they must associate together because of it's a religious obligation for them to come together to be able to serve God. They must come within congregations of like-minded people to associate, to have that opportunity to associate with God. And there is no contract or implied contract between any of the members because their relationship is with each other, but even more importantly, with God and Christ, according to their religious belief. So who's going to be the implied contract with? The members, and are we going to go to court and say Jehovah and Jesus and the members of the Highwood congregation? That's the nature of the relationship between them. And it's their opportunity under Section 2A and Section 2D to have that zone of autonomy, that ability to say within their group, they can define who the members are. And when they come together, I think Justice Wakeling, in his dissent, used a very nice expression. In tab 3, I have the judgment of the Court of Appeal. And at page 115 of the record, paragraph 120, so Justice Wakeling in his dissent said the last sentence of paragraph 120, whether a religion prospers and attracts new members and has influence in the greater community should be the product of the efforts of adherents of a religion and the values of the religion, not the level of support provided by state apparatus, including the judicial branch of government. So the congregation self-defines, and if that's what attracts members, as it says, the values of the religion, that's for them to decide. So if they decide that religion is important to them, they need to conform to the Bible standards of morality, and if they do not, they are excluded from that fellowship. That's for them to say. And they keep their organization private by making sure that there are no property or civil rights that hinge on the question of membership. The congregation doesn't have property. It doesn't employ people. All the members are volunteers. They're making conscious choices as a religious congregation, and their basis of religious fellowship, their religious beliefs, is not to do that. Don't solicit within the congregation. The congregation does not boycott or promote businesses. The religious belief is we're just getting together to share our common values based on the Bible, our common beliefs. And if you like that, great. We welcome the public to come and attend with Jehovah's Witnesses. And if you don't, that's your personal choice. And after a time, if you've been associated with Jehovah's Witnesses and you think this is not for you, you don't come again. You stop. It's not Lakeside Colony. Jehovah's Witnesses are in the community. Their kingdom halls are open to the public. There's no isolated community.
So there's no sin for a member of the congregation to continue business with Mr. Wall even though he has been disfellowed. Is that what you're saying? In other words, could someone be brought up on the carpet in the Jehovah's Witness religion for associating with someone who has been disfellowed and continuing to provide them business?
The answer, Justice Moldaver, is as I gave to Justice Wilson when he asked me the same question, is it's a personal decision. Members make their personal decision based on their religious conscience, but it is a group value because it's part of the religious practice of discipline. Disfellowship is a discipline. And so if a member of the congregation was willfully associating with someone who was disfellowshipped, the elders would likely visit that person, talk to them, and try and reason with them why, as a religious value, they should not associate with that person as long as they're disfellowshipped.
Sorry, standing. Members should generally do things to help that person, could be economically, and in other words, Mr. Wall is a real estate broker. If you're going to buy a house, go to Mr. Wall.
That would not be promoted in the congregation.
That's not promoted.
Not at all, Justice Moldaver. In fact, the evidence is to the opposite. The evidence in the affidavit from Mr. Dixon is that the congregation is encouraged not to use the congregation as a basis for business relationships.
There's no reliance issue here.
No,
All right.
no.
It wouldn't matter anyways.
Exactly. And that comes back to Justice Abella's question about are we mixing jurisdiction and justiciability? Right. Is that now that's the issue of justiciability, is that this is religious doctrine, and that's not justiciable. And that would be whether it's in the context of a judicial review or in the private law context either.
So can I pull you back, and I know you've got some ground to cover yet, but I'm still trying to resolve, undoubtedly imperfectly in my own mind, how to resolve the tension where a civil right, the right to employment, so let's go to a contractual right to employment. Let's go back to Justice Rowe's example, is terminated on the basis of something where Amselem says, you shall not go courts. So the causal determination, right, is religiously based. How do we square that circle? We can adjudicate the claim, but one side is saying, well, the decision was based on our interpretation of a verse from the Bible? How do we deal with that?
So I think the answer to that, Justice Brown, is in the nature of the contract. What is the arrangement between the individuals? So if there was a minister and there's a contract of employment, and that contract of employment says cause would mean you can be dismissed for cause because of no longer believing in Jesus Christ, or no longer believing in a specific religious deity, or practicing conduct which is disapproved by the religious organization. So all other facets of the contract would be before the court. But the reason, I think as you've just pointed out, Justice Brown, that particular subject, whether or not cause is present, would really be beyond the court's jurisdiction. That part of the contract would be not justiciable, because it's truly religious belief. Whether or not it's conduct which is appropriate or a part of the religious process, that's a religious determination. But all the other facets of the contract, if there's notice required, if there's payments on the termination of the agreement, or the way that the parties, how long they can take to leave the property, or give up their vestments, whatever the case might be, that would be provided by the contract and could be enforced by a court.
You said that the entering into a consideration of theological issues is not justiciable, but is that using the term justiciable properly? Is an issue justiciable? Is there a cause of action? Right? For example, is the high church or the low church in the Church of England, closer to the one true faith or whatever? I mean, that's not a justiciable issue, it seems to me. But whether in the circumstances of a given case, it might be necessary to receive evidence of religious practices in order to determine a legal issue, I think that I can see that as being proper, and I'm not persuaded, at least thus far, by your saying, well, such matters are not justiciable. In other words, you seem to be saying that the courts can never turn their mind to such things, even when you need to look at them in order to determine a legal issue, which I'm not sure quite follows.
Justice, I wouldn't say that the court can never turn their mind. I agree. Perhaps the paradigm here is of a trust agreement for the holding of a church property. The question of the property is very much before the court. It's a property interest. Somebody's got to make a decision about who owns the property or not. And sometimes there can be religious elements to that decision, exactly as you postulate. It's the low church, the high church, who owns the property. But I think the analogy of the yellow light from Justice Goncier is what should guide this court, is that you exercise jurisdiction cautiously. How far can you go? Even in Lakeside Colony, there were legal documents that could be interpreted. So there was a basis for the court's jurisdiction. But even assuming jurisdiction, as the court goes through the process, they need to be cautious. We don't get entangled with a religious dispute.
Well, I think the spirit of Anselm, isn't it, to say we accept the religious doctrines, pretensions, whatever, that are brought of the claimant who comes before us. We're not going to question whether he needs, under Jewish religion in the Anselm case, to have a sukkah on the balcony or not. We say, okay, you have freedom of religion. You say for religious reasons you need to have that sukkah on the balcony. Okay, accepting that, where do we go from there? But we're not going to, what Anselm was saying, I think, and at least I thought that's what we were saying, is we're not going to become, some sort of super rabbi or rabbinical council to decide those issues. We're going to just say, okay, the individual has made a case that he has a sincere belief that this is, and okay, where do we go from there? Are there interests that need to be protected, or is there, you could do the justiciability and you could do the jurisdiction first and then the justiciability if you want. But justiciability goes to a question, and we're not going to get into the question of whether or not this branch of a religion is right, or that branch, or this practice is required. We simply say that practice is part of their religion.
We agree, Chief
And we
Justice.
take that, so we consider it,
Right.
but we don't debate it.
Exactly, exactly. And that's why we're saying that in this particular circumstance, the religious decision of Highwood Congregation to disfellowship Mr. Wall is entirely religious. It is religious dogma. It is forbidden ground for the court to go, because there are no property or civil rights that hinge on that decision. And with my 2 minutes that are left, I just want to make one point very clear. I want to come back to the idea of natural justice. Can the court, if, for example, the court does have, if the congregation does have a procedure, rules that might be legally interpretable, does it need to have to resound in natural justice? And the applicant's position is no. Natural justice is a secular determination. There are rules of court. And as it can be seen in this particular circumstance, it's not a court. The meeting between the elders and Mr. Wall, the sinner, is not court-like. It's involving, they're trying to bring the person to repentance. So to try and say that they need natural justice, they need to have standards of natural justice, would be really dictating to the congregation religious belief. It comes back, Justice Deschamps used an interesting terminology in her dissent in Brucker. It's at paragraph 132. And so that's at tab 9, but I don't have time to take you there. I'll just read. It's at paragraph 132, the last sentence. Justice Deschamps said, "Where religion is concerned, the state leaves it to individuals to make their own choices. It's not up to the state to promote a religious norm. This is left to religious authorities." If the court were to review a congregation's procedure for natural justice, it would be promoting the secular norm of natural justice to become a religious norm. That is not the role of courts. That's not the role of state in Canada. It's up to the congregation to decide what they're going to believe and how they're going to practice their religious beliefs. Thank you, Justices.
Thank you. Mr. Siddiqui. Yes?
Chief Justice, Justice of the Court, good morning. Thank you for allowing me to leap ahead of the other interveners this morning. I won't get the benefit of hearing from my more learned friends. My client is the Canadian Muslim Lawyers Association, and therefore I represent lawyers who are often on the forefront of these disputes. The interveners here are unanimous that the state cannot get involved or entangled in religion. However, the interesting issue for this case is, when can the state get involved in affairs of religious organizations? Contrast, for example, the Dawood Bohri case that the Supreme Court of India grappled with, and Syed versus Chaudhry. Dawood Bohri involved questions of religion, and Syed versus Chaudhry did not. It involved concerns about membership and the expansion of the membership list from 197 members to 281. And that was in the context of a hotly contested boardroom battle. I was walking in the old city of Jerusalem in September of this year, visited Al-Aqsa, the Western Wall, and the Church of the Holy Sepulchre, and it occurred to me that religions can have the rarefied atmosphere of the Dome of the Rock, but they can also have the seamy side of human nature. We know the unfortunate cases of priests who engage in pedophilia, for example, or imams who condone suicide bombing. And therefore, I think it's important for the court to exercise some measure of control, and that's why we propose in our factum some factors for a test. The very first of which is procedural fairness. This may have not come out across well in our factum, but what we're saying is the court cannot get involved in the religious internal processes of an organization because members have signed on to those rules. Where it may be able to get involved if there are no rules, and there it may have recourse to natural justice. It's also well established in the case law that the court will look at the internal process of a religious organization and whether that has been exhausted. We've also raised the specter of electoral or membership fraud. And fraud may be a very strong word, but I think you get the idea that what the court may have to ask is there something that brings the integrity of the electoral or membership process into question? And finally, we mentioned that the court may be required to make a determination of religious content or decide whether religion is being used as a cover for irreligious purposes. So certainly in the first respect, the court cannot get involved. I mean, you are not necessarily arbiters of religious dogma. But on the second question, you may have a role to play. I'm going to turn to tab 13 of the appellant's book. There is a case there, Lakeside Colony, and there's a reference there that my friend, Mr. Nam, did not refer to, where it says, "The court is, however, called upon to determine whether the purported expulsion was carried out according to the applicable rules with regard to the principles of natural justice and without malefides. This standard goes back at least to this statement by Sterling J. and Bird versus Wells, a case of 1890 from the English common law, where the only questions which this court can entertain are, first, whether the rules of the club have been observed, secondly, whether anything has been done contrary to natural justice, and thirdly, whether the decision complained of has come to bona fide." That dovetails well with Section 11 of the Courts of Justice Act in Ontario, for example. I have copies for the court here, and I'll just read out Section 2, which says the Superior Court of Justice has the jurisdiction, power and authority historically exercised by courts of common law and equity in England and Ontario. And unless there are any questions from the honourable bench, those are the submissions of the Canadian Muslim Lawyers Association as a friend of this court.
Thank you very much. Mr. Boussy?
Good morning. May it please the court. There are 3 points that I would like to bring to your attention today. The first is that religious membership is a private matter that does not engage a public interest. The law is not equipped to review private religious matters. And third, that this decision will have an impact on my client's membership. First, my client submits that the law is not required, nor should it be burdened, with the complexities of internal religious disputes. Justice does not require the law to extend to private, intricate concern of theological controversy. The law does not extend, as it were, to every nook and cranny of private religious enterprise. Having chosen to be a member of a voluntary religious community, the individual chose to live in accordance with the norms of that community and to live with the realization that that community is the ultimate arbiter of their continued fitness for membership. The law ought to respect this individual's free choice, even though upon the dissolution of the relationship there may be some hard feelings or loss of camaraderie. Western civilization has learned through history's anvil that religious disputations are best left to the adherents. This week we've commemorated the 500 years of Luther nailing the theses to the Wittenberg church door. And of course we're all aware of the tumultuous history that followed as various heads of state took sides in what was in essence a theological dispute. We've learned from our history And this court, through the jurisprudence that was referred to here earlier, recognized that the best course of action for the state is to leave internal religious disputes alone. Now, individually, we may sympathize with and have compassion with how or in our view, how a religious member's membership has been treated by the religious community. But our law has no place for such sympathy. Not that the law is harsh or cruel, but that the law is just in its realization that a person is free to join or not to join, and that a religious community and its norms of membership, rooted as they are in theology and religious history, is to be respected. My second point. The law has wisely recognized that it is not equipped to engage in theological disputes. Secular law has no privity to the theological and socially contextual complexity of religious community under review. Our law has no understanding of such matters, and I suggest nor should it. Consider what might be the result of the law taking on religious disputes. A religious community may argue about the nature of God, whether there is a Trinity. Should the law hear a case about the lack of procedural fairness from those who lost the debate about the Trinity? Debates about metaphysical truth within the context of religion are common. In fact, it might be appropriate to say that differences of opinion in religious matters are the norm. Over the century, religious communities in the West have shown themselves quite adept at handling religious disputes. Unbridgeable differences have resulted in disgruntled members leaving and forming their own religious communities. That, I suggest, is a mark of a free society, free to enter and free to exit. My third and final point is the effect on our membership. Should religious communities have to be concerned about providing procedural fairness, as secularly understood, it will be an imposition on the religious beliefs and practices. There are currently some 33,000 religious charities in Canada, and much of the work carried out by charities is done by volunteers. Now, this system works because these people are religiously motivated. And in our experience, with our membership of 3,400 members across the country, we find that many of our members even struggle trying to file the annual CRA T3010 form. They are religiously motivated to carry out good work of the charity, but are not so motivated to carry out government regulations. Now, imposing secular norms like procedural fairness on religious decisions will only make the volunteers, take the volunteers from their good works. First, they may not understand the legal nuance and properly carry out the secular norm. Second, they will be hamstrung by disgruntled members with an axe to grind.
I'll just ask you to finish up.
Yes. My final point, my final statement is that there are limited resources to deal with court actions. Their community, indeed our country, needs those resources and energy spent in ministry, not fighting over procedure. Thank you very much for your time.
Mr. Sukima.
Good morning, Justices. A state actor, including a court, must never go beyond its jurisdiction. This court is therefore asked to first consider what kind of institution a civil court is and what kind of authority the courts should or should not claim. Jurisdiction, of course, means the authority to decide, or literally to speak the law. So the question is, does the judiciary have the authority to decide who gets to become or remain a church member, or who gets to participate in the sacraments? Or does the judiciary have authority to dictate how church discipline ought to be done, or to supervise church discipline? Are these matters of civil or spiritual jurisdiction? Now, my client, ARPA Canada, submits that the civil government and churches both have limited and distinct jurisdictions or spheres of legitimate authority. And this basic distinction between civil and spiritual jurisdiction is a source of freedom and religious pluralism. So in summary, we submit that church discipline and membership is, one, not a legal matter falling within the court's civil jurisdiction, but is, second, a spiritual matter falling within the church's spiritual jurisdiction. For the first point, that it's not a legal matter, I rely primarily on my factum, paragraphs 25 to 28. But I'd like to mention our friends, the respondents, write in paragraph 10 of their reply factum that, quote, there is no apparent logic in recognizing and enforcing a requirement for procedural fairness only in a lawsuit concerning different legal rights, end quote. But with respect, the logic seems clear. The legal or civil right is what is captured by the court's civil jurisdiction. And the respondent argues in that same paragraph that it would be strange for a court to review a decision that has a small impact on a property right, but not to review a decision that has a major impact on one's familial or social life. But with respect, that isn't strange at all. The property right is a legal right, and the other interests affected by goings-on in a church or church discipline may be familial or social and be much more important to a person than property without being legal. So church discipline is not a civil or legal matter, but I'd like to now address how it is a spiritual matter from my client's Reformed theological perspective. I'd like to address the deeply spiritual nature of church discipline. The Reformed confessional documents teach that churches have a jurisdiction over church discipline and church membership. It is, you might say, at the very core of the church's jurisdiction. And just to illustrate for you that there are churches out there who have these kinds of beliefs, we've included a short excerpt from both the Belgic Confession and another from the Heidelberg Catechism in Appendix A to our factum. These are binding statements of doctrine for many Reformed churches in Canada and the world. And these documents provide an important perspective on how this case might impact other churches that are not party to this case. The former, the Belgic Confession, states plainly that the exercise of church discipline is one of the marks of the true church, along with the preaching of the gospel and administering the sacraments. And in these matters, it says the church is governed only by the word of God and subject to Christ as its only head. And the Heidelberg Catechism teaches church discipline as one of the keys of the kingdom by which the kingdom of heaven is open and closed. The consequence of excommunication, the exercise of the key of discipline, is exclusion from the sacraments. Now, these documents, I suggest, raise questions about a church's ability to submit to any order of any civil court with respect to church discipline and exclusion from or inclusion from the sacraments, which is the primary consequence. For a church that holds to such teachings, these raise the practical question of, let's say a court quashes a discipline decision on Friday, must that church then admit the member to the Lord's Supper on Sunday? We've included some materials for you, tab 6 of our Book of Authorities, where a theologian's writing about allowing someone to dishonor Christ, the body of Christ, and the sacrament. What happens when a discipline decision is quashed? Now, if a church is simply a multilateral contract, as has been suggested, then it seems to us that the flip side of a member taking a church to court over a disciplinary decision as essentially a breach of contract would be a church bringing someone before a court who, say, refuses to submit to their teachings, if that's their end of the bargain. In an excerpt we've included for you from John Calvin, he actually says, this important Reformed theologian, says that it would be wrong for the church to bring accusations to the state against those who do not obey the church's spiritual authority. And this court said something similar in the Ukrainian Greek Orthodox Church case, as you'll see at footnote 47 of our factum. So it may be that a court will have to consider religious principles to decide a civil dispute, but not to decide membership in the church or the kingdom of God per se. Thank you, Justice. This is my submission.
Mr. Gallowitz. Right.
Chief Justice, members of the court, my name is Mark Gellowitz, and I'm here with my colleague Karen Sachar on behalf of the intervener, the Canadian Constitution Foundation. In this appeal, the respondent argues that separate and apart from established principles of judicial review of administrative action, the courts have a freestanding jurisdiction to undertake procedural review of the decisions of private voluntary organizations. I say this is misconceived because it ignores the necessity of an underlying legal right as the precondition for any form of judicial review. It admits of no limits to the court's interference in private associations and the constitutional right of all Canadians to associate or not associate with whomever they choose. The courts do not enjoy a roving jurisdiction to do good works or to enforce for all Canadians in their private lives the court's view of appropriate procedure. Civil society does not play by the rules of administrative law. The social interactions between private individuals, the decisions they make about their association or non-association with other private individuals, do not require notice or a fair hearing or written reasons that can be subject to appellate review. In the domain of voluntary associations with no public aspect and where no legal right is affected, the question whether the procedure that they followed is good or bad or atrocious is simply not within the court's purview. Natural justice sounds like something no one could object to. But it's a legal construct. It's a legal construct that has no application in the private realm of religion, or who gets to join the chess club, or whether the hockey coach was right to keep your kid on the bench. Members of religions and members of private associations, voluntary private associations, are not legally entitled to procedural fairness in the abstract. They are not legally entitled to natural justice in the abstract. These procedural standards are not rights that exist in the air, waiting to be enforced. They're norms to be applied to decisions made in relation to legal entitlements. And Justice Rowe, let me just make a comment about the Lakeside Colony case. When you're asking yourself whether that case was an expansion of the jurisdiction of the courts, you should bear in mind, I think it's procedurally important, that in that case, it was the religious community, the colony, that invoked the jurisdiction of the court and actually asked for a declaration that the defendants were expelled properly from the court. So the religious community came to the court and said, help us out and decide this question for us. In and of itself, that should cause you to tread lightly on whether that case stands as a good foundation for a new jurisdiction for the court. I say that in the absence of an underlying legal entitlement, there is no standard for the court to enforce. No natural justice standard, no procedural fairness standard, and nothing to which such a standard could be applied by a court. In other words, natural justice is a test that a judicially reviewable decision must pass. It is not a test about whether a decision is judicially reviewable. Thank you, Chief Justice.
Mr. Paulsogopoulos. Yes.
Good morning. In my attempt to advance three arguments, and those arguments are first that Section 2A of the Charter protects the religious freedom not only of individuals but also of religious communities and organizations. Second, that consequently those communities and organizations have the right to protect and maintain their identity and their integrity by self-defining. And third, that decisions related to membership and discipline are ecclesiastical decisions and ought not to be interfered with by the court. But what I want to hone in on today is that second argument that deals with the right of these religious communities or organizations to maintain their identity by self-defining. Religious practice is public and it's communal in nature, and as a result, religious individuals often associate or congregate together in in doing so, do so around vehicles or instruments or certain entities that allow them to fully benefit from their Section 2A religious freedom rights. In the context of this case, that vehicle is the Highwood Congregation, but in other cases, it may be something completely different. Highwood Congregation is an unincorporated entity. In Loyola, it was a faith-based school. In La Fontaine, it was a church, but it could also be a seminary or a faith-based hospital or any other charitable organization, as Mr. Bussey referred to, that engages in religious activity or ministry. And the common theme here, or the common thread rather, is that religious individuals congregate together around certain vehicles, certain instruments, certain entities in order for them to carry out and live out their faith. And the point I want to make, or the point I urge this court to consider as it determines how to deal with this appeal, is that any threat or any possible interference with that vehicle consequently results in a direct threat or direct interference with the 2A rights of the individuals that make up that community or that organization or that congregation. And, you know, I wish I could take credit for that idea or that argument, but it's not mine. It permeates our law. We saw that recently in Loyola, where this court recognized that state interference or the state compelling a Catholic school to teach Catholicism in a manner that they didn't seem or believe to be Catholic was undermined the liberty of the members of the community who have chosen to give effect to the collective dimension of their religious beliefs by participating in a denominational school. In La Fontaine, this court recognized again that the right, or the ability rather, to build a place of worship is an integral part of freedom of religion. And so in this appeal, in the context of this case, the integral part of the religious freedom, or the benefiting of the religious freedom of the members of the Highwood Congregation, is the Highwood Congregation. And so it's important to consider the impact a decision of a court on the Highwood Congregation will have on the members of that congregation, and more specifically, in my submission, their religious freedom. Because as we urge in our factum, and as many of the interveners urge, a decision related to membership or discipline is an ecclesiastical decision. And again, this was recognized by Justice Moldaver and the Chief Justice in their concurring reasons in Loyola, and so I would urge the court to adopt those reasons, to expand on those reasons in its dealing with this appeal. Now, my friends may say, we're not asking the courts to engage in a review of an ecclesiastical decision. We're not asking the courts to review doctrine or theology. And with all due respect to my friend, I think that misses the point. The process here, they may say, we're only asking you to review the process. But the point here is that the process is ecclesiastical. It is religion. It is based on doctrine and theology. In the Catholic tradition, one of the groups I represent is a Catholic group. In the Catholic tradition, the process is defined and determined by canon law. And if you pick up the Code of Canon Law and read it, it reads very much like the rules of civil procedure. But they're not the rules of civil procedure. It's canon law. It's religious. It's ecclesiastical. I'm going to end on this point. If you look at this appeal, and I look at it simply for illustrative purposes, if the court here decides that it's going to interfere with the Highwood Congregation's decision related to discipline and ultimately membership, I submit that what it does is it treads it not only toes the line, it crosses the line of breaching that wall that Absalom builds. Because what it does is it violates, or it puts on the line, the religious integrity and the religious identity of the Highwood Congregation or any other organization that we may be dealing with. And the result of that would be a violation of not only the 2A freedom of religion of the congregation, but of each and every individual that makes up that congregation and chose to associate under it.
Thank you so
Subject
much.
to any questions.
Thank you. Derek Ross.
Good morning, Justices. As an NGO with special consultative status with the United Nations, Christian Legal Fellowship wishes to bring an international law perspective to some of the issues that are before you today. And to that end, I plan to briefly address 2 points. First, the right to autonomy of religious communities is a fundamental principle recognized in international law. Canada has committed to uphold that principle through its international commitments. The present case demonstrates a need and presents an opportunity to affirm that principle in Canadian jurisprudence. And second, as the international cases demonstrate, in the event of an internal religious disagreement, the solution is not to coerce a religious community to accept religious practices, beliefs, procedures, or members contrary to its will. With respect to the first point, as you've heard this morning, a central consideration in this case is the freedom of religious communities to determine and administer their internal affairs without interference. And there is strong international support for this freedom, which has traditionally been referred to as church autonomy, more recently as the autonomy of religious communities, or simply religious autonomy. International jurisprudence recognizes religious autonomy as a key component of both freedom of religion and of freedom of association, and as a requirement flowing from the duty of state neutrality. It is therefore understood to be a core characteristic of a free and democratic society. And Canada has committed to uphold a number of international treaties that affirm this principle. These include the Vienna Concluding Document, which is at tab 1 of our condensed book, which guarantees the autonomy of religious communities to organize themselves according to their own structure. The Universal Declaration of Human Rights and the International Covenant of Civil and Political Rights both protect freedom to practice religion in community with others, and these have been interpreted by UN bodies to protect the internal workings and decisions of religious communities from state interference. Further guidance can be drawn from the European Court of Human Rights. That court has interpreted provisions of the European Convention virtually identical to the UN documents I just mentioned. And that court has held that the principles of state neutrality and religious autonomy prohibit state actors, including courts, from interfering with membership decisions or criteria of religious communities, and that the autonomous existence of religious communities is indispensable for pluralism in a democratic society. The second point is this, that in the event of an internal disagreement, religious autonomy may be seen as competing with other interests and claims, but the solution is not to coerce that community to accept procedures or beliefs or members contrary to its will. Such coercion harms not just the religious community, but as the European Court has held, it interferes with the proper functioning of democracy itself. So the overwhelming majority of cases before the European Court, and we've highlighted some of them in our condensed book, have upheld religious autonomy against competing claims. In the Ukraine case at tab 2, for example, the court rejected arguments that an individual's right to manifest his religion superseded a church's membership requirements. Instead, the individual's freedom of religion is exercised by his or her freedom to leave the community. In the Romania case at tab 3, it held that individual freedoms of association and religion do not give rise to a right to dissent within a religious community, and that religious communities must be free to respond in accordance with their own rules and interests to internal disagreements. And finally, in the Bessarabia case at tab 4 of our condensed book, the European Court held that forcing believers to worship with those outside of their community is a fundamental rights violation, even if the state thinks that doing so is necessary to preserve peaceful unity and social cohesion. There are compelling underlying reasons for these decisions, which we spell out further in our factum, not the least of which is that the autonomy of religious communities is necessary for the individual freedoms of its members. That unless communities are free, believers cannot be free. And this benefits society as a whole, not just believers, but unbelievers as well. To conclude, jurisprudence rooted in Canada's international commitments and similarly worded documents reflect an established pattern, a pattern that jealously guards religious autonomy, particularly in the context of membership decisions and self-definition. This is a basic standard agreed to by a community of states, including Canada, and in our submission should be the minimum standard of protection afforded by the Charter.
Okay.
Subject to any questions. Thank you.
Mr. Balpreet Singh Bopati. You did a good job.
Good morning. WSO submits that state religious neutrality is a charter value that constrains the ability of courts to judicially review the membership decisions of religious associations. When the court exercises its jurisdiction to judicially review the membership of a private religious body, even where it implicates civil or property interests of an individual, it's departing from the charter value of religious state neutrality.
When we have have a charter right?
So we believe that the charter value, even in private situations, is applicable, and it underlies those charter rights. So we believe that only where there's an overriding public interest at stake that requires the state to no longer remain neutral, the court should only intervene in that sort of a situation, and only where it would reinforce or advance the free and democratic values of the charter. In doing so, you would have to have a net salutary effect that is of benefit with respect to the free and democratic values of the charter. So the court has recognized in Saguenay that religious state neutrality creates a public space free from coercion, pressure, and judgment, and it protects individual freedom and dignity, and furthermore, for a multicultural state, it helps and preserves that nature of the multicultural state. Religious neutrality extends not just to the state, but also to its institutions, including the courts, and the charter value of religious state neutrality is core to the legal framework that the court has developed around Section 2A and Section 27 of the charter. The courts recognized in Amselem that requiring the state or its institutions, like the court, to interpret matters of faith interferes with profoundly held personal beliefs, and the state's not in a position to be an arbiter of religious dogma. The state can't determine what's correct belief, or it can't determine between various interpretations of belief. A state departs from neutrality, is no longer neutral or secular when it chooses a certain religious belief over another. Multiculturalism is premised on the basis of equality of all religious groups and cultural groups. When one particular religious group or belief is chosen over another, it creates a hierarchy between believers or between groups. Maintaining and enhancing multiculturalism in Canadian society requires a sense of equality between these religious groups and communities. We recognize, however, that the state cannot and should not remain neutral to all beliefs and practices that are religious in nature. We believe that the state can depart from that neutrality where there is an overriding public interest and where there's actual harm being created by remaining neutral. We believe that creating a free and democratic society, which is the aim of the charter, where it's forwarded, where it's advanced, the state can intervene in that sort of a situation. But for the state to negate the good that's achieved by maintaining neutrality, the result or objective being sought by intervening must be greater than what would be attained by remaining neutral. Any intervention that does not meaningfully further these principles won't reach the threshold of an overriding public interest that permits the state to deviate from its neutrality. Specifically with respect to membership, we believe that who to worship with is a core part of freedom of religion. Membership decisions, of course, are covered by religious freedom, but as the other interveners have said, the process that gets to that decision is also a part of that freedom of religion. Putting external standards or normative judgment on that deliberation, on that process, is problematic. By reviewing a decision to reject or deny membership to an individual and providing its reasonings as to whether the decision was substantially or procedurally fair, the court's imposing its view on what is appropriate over that religious community. Whatever standard the court sets to determine adequacy becomes the standard of the state on these religious matters, and a hierarchy is created between those who are determined to have done it wrong and those who have done it right. So, with respect to reviewing membership decisions, our submission is that the charter value of religious state neutrality allows the court to exercise the judicial power of judicial review over membership decisions only where there's an overriding public interest at stake. And this will be only in very rare instances where the charter's broader free and democratic aims are at stake, and deviating from neutrality would be important to preserve or promote these objectives in a meaningful way, and where maintaining neutrality would result in actual and significant harm. Absent these exceptional circumstances, WSO submits that the court should not exercise the power of judicial review over membership decisions of religious associations, and this is important to preserve and maintain the free and democratic aims of Canadian society, and also the notion of equality that forms the bedrock of our secular and multicultural nation.
Thank you. Mr. Chipper.
May it please the court. My clients are concerned that the process of litigation is a significant burden on their exercise of freedom of religion under the Charter. That concept is discussed under tab 4 of our condensed book. I won't take the time to go there this morning, but it is the issue that brings us here today. Schwartz and Appel discuss the concept of this burden. Under both the Charter, but also under the common law, a test has been developed by the court that I think will help, by the courts that will help this court when addressing a religious question like we have before us today. And the question is simply this: if we remove the religious question, is there anything left for the court to deal with? And as you go through our authorities, you'll see that over and over again, as in the case of Reed from the federal court in tab 1 of our condensed book, when the court took away the religious question, there was no cause of action left. There was nothing to decide. And I think that can be applied in this case as well. And if you note under tab 2, the same question was addressed in a case involving a church here in Ottawa, and when they took the religious question out, again, there was nothing left for the court to address, and this applies to both process and substance, so both the process of making the religious decision as well as the substance. What is the remedy then? What is the remedy? Well, the courts have said the remedy is to leave. That's what the European Court of Human Rights said. If you don't like a question, and in fact, in that case, it involved a question of employment. When a pastor did not want to work with female pastors or priests and was therefore fired, the court said, your option is to leave. If you don't like the religious decision made, you leave, even if we're talking about an employment decision. So if we take religion out of that question, there's simply nothing left for this court to deal with. And one has to keep in mind that just because one can make a decision doesn't mean that one can enforce the decision. And you'll notice from our case, one of the cases in our factum, that the Solomon Islands High Court decided that there had been a problem with process, but then said, there's nothing we can do about it. There was a problem, but you can't force, as they say, that you can't force the horse. You can take the horse to water, but you can't make it drink. Finally, one has to ask this question, and that is there a privacy consideration that should apply in this case? And we point out in tab number 9 that this court has always said that it is an important privacy principle, a charter principle, that one does not go into an inquiry into the faith of an individual, particularly a minority faith, because of the important personal questions that that would raise, and the court just is going to do everything it can to stay away from issues that are of the nature of privacy. Finally, let me point out that this particular question has been addressed many times by the highest courts in Europe and the United States. The United States Supreme Court, in many cases, including the ones that we've placed before you, have said that these are the kinds of questions, and in fact, the process as well as the substance. So it's important that they've said natural justice is just a foreign concept when we're talking about ecclesiastical review. So the United States, European courts have come to the conclusion, and that's under tab 8 in our condensed book and tab 7, that there is no role for the court when one is going to consider a religious question, whether it's related to membership or whether it's even related to the employment of the pastor of a congregation. Those are our submissions, and thank you very much for this time.
Mr. Cameron. Yes.
Good morning. If it please the court, I'm going to talk about 3 issues this morning. The first is that no individual has a right to compel unwilling associations. The second is that commercial activity should not be regulated by the idiosyncrasies of individual judges because of the restrictions or protections in Section 2D of the Charter. And the third is a pragmatic or policy implications point. My first point is that the Charter under Section 2D protects the ability to do collectively what one has a lawful right to do alone. Not only is there no individual ability to compel one's fellow citizens to associate, attempting to do so offends the legal maxim, it's Latin, I won't attempt it, it's in paragraph 1 of my compendium, but that there be no consent under force or duress. A judiciary that attempts to compel the members of a private religious organization to associate against their wills using Section 2D of the Charter misapplies the law. Any resulting association from such unlawful interference, be it in business or in worship, is a sham because it is not voluntary. Any business contract stemming from such coercion would be unenforceable. My second point is found at tab 1, and I'll turn you there with respect to paragraph 33 of a case called AI Enterprises Limited versus Bram Enterprises. It's a 2014 unanimous decision of this court. And the court in that case said it was in consideration of expanding the tort of unlawful means. And the court said that it would be unfavorable to expand the tort of unlawful means because that tort should have a limited role and that the common law in the Anglo-Canadian tradition has generally promoted legal certainty for commercial affairs. That certainty is easily put in jeopardy by adopting vague legal standards based on commercial morality or by imposing liability for malicious conduct alone. The majority in Allen, for example, rejected the view that malice was a sufficient basis for liability on the basis that it was too vague a notion to be applied by the courts. Then at the bottom of that paragraph, it says, regulating commercial activity should not, it has been said, depend on the idiosyncrasies of individual judges. That's a quote from a Mogul steamship from 1889 from the House of Lords. In paragraph 34, the court said that expanding the tort of unlawful interference with economic relations, what is called the tort of unlawful means, would interfere with fundamental rights of association and expression. And then the court makes the exact same point at the end of that paragraph 34. And it's talking about charter freedoms. It's talking about charter rights. Now, this court has said that vague conceptions of commercial morality and the idiosyncrasies of individual judges should not be permitted to determine commercial realities. But today we are talking about the expansion of something far more pervasive and therefore exponentially more invasive, and that is the expansion of judicial review. And if you've read the decision of the lower court judge and the Court of Appeal in this case, you'll see that there are the marks of vague conceptions of commercial morality and certain idiosyncrasies. My third point is that this court should not miss the significance of this case. The removal of bricks from the foundation of a structure impacts the building that is built on that structure. And this would not just be the removal of a brick from the foundation of Canadian society, it would be the removal of a pillar, a very significant pillar that many associations, both private and privately religious, rely on. Not just hockey teams, not just baking classes. Substituting the decision of the court for private membership decisions makes the court the head of those organizations. If the judicial rationale in this case is permitted to hold sway, it will fundamentally alter our nation, and not for the better. And I'm not just talking about the Jordan issues that would be incurred by having numerous delays and clogging the courts. In conclusion, it is no more lawful to compel a church to grant or restore membership to an individual than it is to compel an individual to attend a church or to attend church at all. Only the government can violate a charter freedom. Choosing not to associate with someone is an exercise of freedom of association. It is not a violation of it. It is the function of courts to uphold the exercise of charter freedoms, not infringe them. And I would respectfully say that in regard to fundamental freedoms, it is a fundamental obligation of courts to uphold those freedoms and not attempt to find a way around them. Thank you so much.
Thank you. Mr. Millen.
The submission of the BC Civil Liberties Association is that the first and most important question is what law governs the relationship between the parties. And in this sense, I'm going to pick up on some of the submissions of the appellant and Mr. Gelowitz for the CCF. Not every relationship in our submission among individuals creates legal rights. The simple fact that people have associated with each other is not sufficient. The bare existence of the group on its own does not create legally enforceable obligations. More is required, typically an intention to create legal rights and obligations as evidenced by active steps taken to do so. Absent legal rights governing the relationship, there is nothing for the court to adjudicate, and hence it has no jurisdiction over a dispute that arises within the relationship. The Bruker case is consistent with these principles. In that case, Justice Abella, for the majority, held at paragraph 47 that a get was negotiated between two consenting adults, each represented by counsel, as part of a voluntary exchange of commitments intended to have legally enforceable consequences. This puts the obligation appropriately under a judicial microscope. End quote. Having first determined that the parties intended to create legally enforceable obligations, the court went on to interpret and apply them. Likewise, in the Shergill case mentioned in the factums of both the appellant and respondent, the UK Supreme Court at paragraph 43 quoted from a prior decision of Lord Bingham, in which he wrote that if the claimants have a legal right, it is justiciable in the courts. Now, these may seem to be trite statements of law. I recognize that, but in our submission, they're fundamental to this court's deliberation of this case, because you have to start with a legal relationship before you start applying standards to that legal relationship. And we have enumerated in our factum the various ways by which legal obligations can arise. They're well known: legislation, partnerships, contracts, torts. The Lakeside case that's been discussed earlier involved legislation, involved articles of association, and a constitution. The majority of the court in that case held at paragraph 45 that both the articles and the constitution are therefore the source of legal obligation between the members of the local colony. Now, in this case, in the court below, Justice Wakeling touched on this point at paragraph 113, when he wrote that the likelihood is very low that the group's members will have made promises that they intend to be enforceable in a civil court. And in our submission, that is exactly the question that must be answered first, before you get into the dispute or any other element of this case. Did the group's members make promises to each other that they intended to be enforceable in a civil court? If not, there's nothing for this court to decide. In answering that question, the court should take into account the principles of freedom of religion and association that have been discussed previously. The court should also consider what structure and terms the members have adopted for their association. We haven't yet touched on this morning the Basine case. In our submission, that's a useful analogy. The court in that case, as you know, held that parties to a contract must act in good faith when carrying out their contractual obligations. The core and primary legal framework is an existing contract, to which good faith is applied as a standard. Good faith is not a freestanding standard. It only applies to parties to a contract. Only parties to a contract are required to act in good faith towards each other. Likewise, this court's decision in Dunsmuir imposes a reasonableness standard on public actors making administrative decisions. Dunsmuir does not stand for the proposition that all decisions must be made reasonably. Private actors are entitled to make unreasonable decisions. They're entitled to act in bad faith towards each other if they're not in a legal relationship. Only public administrative decisions are required to be made reasonably. And fundamentally, this is an application of the rule of law principle. All exercises of the court's jurisdiction must find their source in law. That's a paraphrase of paragraph 28 out of Dunsmuir. Turning to the present case, review for procedural fairness, which is the claim advanced by the respondent in this court, is not a freestanding enforceable legal right that is applicable to all relationships and all decisions. Not everyone is legally required to act in good faith or reasonably or fairly. Procedural fairness can only apply if the court first determines that the parties intended to create a relationship with legally enforceable consequences.
Thank you, Mr. Millen. Court will now rise for its morning recess. We'll be back around 11. Thank you. Mr. Fader?
Chief Justice, Justices, I want to begin with two preliminary points about what is and isn't an issue in this case. The first point is this: Mr. Wall does not challenge the substance or merits of the Judicial Committee's disfellowship decision. He does not argue that its decision was wrong or unreasonable or not based on the evidence or inconsistent with religious doctrine or custom. He does not argue that the Judicial Committee judged him to be insufficiently repentant for his sins. That is not the principal dispute. Nor is he asking this court or any other court to determine who is or can be or should be one of Jehovah's Witnesses. He's also not asking any court to inflict some enduring association with Mr. Wall on the Jehovah's Witnesses. None of those are his arguments. The only argument Mr. Wall makes is that the procedure followed by the Judicial Committee was flawed. It breached the requirements of natural justice imposed at common law. He was denied procedural fairness. To use the Chief Justice's term, he is not asking anybody to be a super rabbi, or in this case, a super elder.
So it is a judicial review.
There's been a lot of time spent this morning talking about whether it's a judicial review or not. I don't want to get caught up in the vernacular, in the terminology that we use. He is not seeking the public law remedy of judicial review. It's not an administrative law case. Judicial review in that sense, Justice Wagner, is concerned with policing the delegated exercise of statutory powers for their legality. As we know from cases like Dunsmuir, courts have a constitutional duty to ensure that the executive branch doesn't exceed the powers that have been given to it by the legislative branch. Mr. Wall has never argued that the Judicial Committee is a public authority or otherwise part of the executive branch of government. He has never argued that the Judicial Committee or the Highwood Congregation has statutory powers, much less that they've exercised them or exceeded them.
Then how do we even get to looking at procedural fairness, natural justice, which are legal constructs? If you're not, this is an application for judicial review where we're being asked to examine procedures of a body that you accept is not subject to scrutiny by the state or the courts, and yet you invite us to apply scrutiny to what they do as a freestanding obligation on the part of everyone, notwithstanding whether they're covered by judicial review, to follow the rules of natural justice as developed by the courts. Isn't that the implication of your argument?
I agree with almost all of that, Justice Abella. I wouldn't go so far as to say they're not subject to scrutiny by the courts. What Mr. Wall relies on here, as he did in the courts below, is a long line of cases going back to the 19th century, included in which is not only Lakeside Colony, but Lord Denning's decision in Lee and Showman's Guild, and more recently the UK Supreme Court's decision in Shergill. These are cases that impose a common law, a private law obligation on voluntary associations or domestic tribunals to observe the rules of natural justice when they engage in certain types of decision-making.
Even in the absence of a property or contractual issue?
Well, there is a debate, needless to say, in that regard, and I'm going to deal with it. I accept that under our case law, there is some conditioning of access to that form of procedural review as we've styled it in our factum. I will tell you that if we look at the most recent statement from the Supreme Court of the United Kingdom, that conditioning is absent. But in any event, my client meets the condition.
If the condition is, show that this is of sufficient importance to warrant the court's involvement, and I say that is what Lakeside tells us, and I'll tell you also, I have an argument that is grounded in logic, he meets that condition in any event.
So you're not asking us to change our jurisprudence, you're saying that Mr. Wall comes within it?
Correct.
Okay, thank you.
Exactly correct. With those two preliminary points out of the way, I want to...
Saying that this sufficient importance is independent of any property or civil right? Is that what you're saying?
I am saying that what Justice Gantier says in Lakeside is that the question is, and Justice Rowe took us to the passage in question. He says, the colony conceives of the right one way. The Hofers conceive of it in another way. But whether it's a property or a civil right or a contractual right, it's not so much the question. The question is whether it's of sufficient importance to warrant the intervention of the court.
If it's a property or civil right.
That is of sufficient importance.
The impact of the decision sought to be reviewed, Justice Brown.
That's not how I read it. It says if the defendants have a right to stay, the question isn't so much whether, as the colony saw it, it's a property right, as the Hofer saw it, it's a contractual right, but whether the right, is of sufficient importance.
Right, but the reason in the context of Lakeside that Justice Gantier is looking at the right and assessing its sufficient importance is because it's a right, the ability of the Hofers to stay in their residence, that will either remain extant or disappear, depending on whether their expulsion was valid. And so what he's doing, in effect, is examining the consequences of the expulsion. And he concludes that they are, the expulsion is of sufficient importance, and its consequences are of sufficient importance to warrant the court's involvement. Why? Not because it's a property right, not because it's a contractual right, but because it's akin to the right to earn a living that Lord Denning tells us in Lee and Showman's Guild is sufficient to justify the court's involvement.
I don't want to belabor it, but that's not how I read it. They're talking about, irrespective of how you characterize the right, the question is it's a right. I mean, one does not have a justiciable right to earn a living. I can't go and obtain an order requiring someone to give me a job. It has to be based on a legally cognizable basis, so property or contract, as they identified. Maybe let me be more specific. Can you address the argument that was put to us and that I encapsulated earlier, that really what it is it says the fact that you have a contractual right or a property right is a precondition, but it may not be enough, that it has to be a right of sufficient importance, but it has to be a legally cognizable right nonetheless.
Right, and that's a new gloss to my ear as of this morning from Mr. Nam, and my reaction to it is to say I'm not quite sure what it means. Is a partnership interest a more important right than a shareholding? Is a right to sue for defamation better or worse than a right to sue for a breach of contract? Does it matter what the quantum is? I don't know what to make of that as a concept. The idea that now not only we need to condition access to this procedural review on the existence of a right known to some other part of the law, but now we're going to set up a hierarchy of such other rights, and only certain of them will satisfy the conditioning.
What is your test for sufficient interest? How do we draw the line between, a minor quarrel in a bridge club about who does lunch next time and the case you say should attract the court's attention?
Chief Justice, I say we do it the way the common law has always done it, which is incrementally with reference to the prior cases. I appreciate that you did, and I'm giving you the best answer I can.
Okay, thank you.
Let me formulate an example, if I might, to pick up on Justice Brown's point. If Justice Gantier and the court, because all the members of the court joined in, say current Chief Justice, meant that there had to be, if property read paragraph 9 says there has to be a property interest or a contract interest, and that property or contract interest has to be of significant, sufficient importance. Let me give you an example. in the Hutterite case, there were valuable properties, farmlands and the like, and I think there may have been a patent or something. If there are vestments that go with certain religious ceremonies, and their value is almost inconsequential, just $20 or something, is that not an instance where, yes, there's a property interest, but it relates to something of such modest value that it would be necessary to inquire into, to have regard to ecclesiastical matters to determine the disposition of something which is of very little value versus a share in valuable farmland, for example? Might that be an instance, reading Gontier, Justice Gontier that way?
If that gloss, if I can call it that, I don't mean to use the term pejoratively, I just mean to say it's an additional requirement. If the gloss of importance in the civil or property right is valid, then I can conceive of assessing importance as you propose, Justice Rowe, which is with reference to the quantum of the claim. That is one way of doing it. The difficulty I have is I look at the case law and putting to the side for the moment Justice Brown's reading of the one passage in Lakeside, I see no reference to assessing whether a right, if engaged, is sufficiently important. There's no suggestion that now we have to do this hierarchy of rights exercise, whether by looking at the quantum of damages at stake or something else.
So just now I'm a bit confused. I apologize. Are you saying there is a two-step requirement? First is a property or civil right issue engaged, and then is it of sufficient importance to warrant the court's intervention? Or are you saying it's not clear that there needs to be an underlying property or civil right?
I'm saying, Justice Avella, there doesn't have to be an underlying property or
That's
civil
what
right.
I thought. So you are trying to get us, if respectfully, to reinterpret what the court said in Lakeside, where it says the courts are slow to exercise jurisdiction in paragraph 6, but they have exercised jurisdiction where a property or civil right turns on the question of membership. And then they go on in paragraph 9 to say the question is not so much whether this is a property or contractual right, but whether it's of sufficient importance. So I don't see anything in the judgment that would allow us to interpret out an underlying requirement for a property and civil right. Now, you may persuade us that there is one, but interpreting the judgment to read out that requirement seems to me to be a stretch.
Right. If you'll allow me, I do have an argument about why looking to a property or civil right, important or unimportant, is not the right way to come at this problem. And if you'll allow me, I promise I will come to it. I do want to put down a marker, though, that if you look to the Supreme Court of the UK's decision in Shergill, it is clear that there needn't be a property or civil right in order to get the type of procedural review that I am speaking about today.
That's why I asked you if you want us to change our jurisprudence. If you're asking us to reformulate the Lakeside test in accordance with the UK Supreme Court, I think that's an argument that I'm listening to with different ears from whether or not you want us to apply our own jurisprudence.
Justice Abella, maybe I can simplify the syllogism this way. I read Lakeside differently than you and Justice Brown. But if your reading is right and mine is wrong, then I want you to change the law to be in keeping with Shergill.
Good luck.
Thank you. I want to turn for a moment to the heft of the appellant's burden on this appeal. Bearing in mind that this appeal arises from a threshold determination about whether the court does or doesn't have jurisdiction even to hear Mr. Wall's allegations, i.e. there's been no adjudication on the merits, and what the appellants are trying to foreclose is any adjudication on the merits. I say that the appellant's burden is to convince you of the following.
Where an unincorporated organization, or at least an unincorporated religious organization, makes a decision affecting one of its members, and especially a decision to expel her or him, courts have no ability, no power, no jurisdiction to review even the procedure by which that decision was made. And that is so no matter how unfair the procedure, and that is so no matter how serious the decision's consequences, subject to only one qualification. According to the appellants, the court can review the procedure if and only if some other legal right, which is what we've been talking about, turns on the decision, and if the question of the decision's procedural fairness arises incidentally in some action to enforce that right. And we had some new glosses this morning. We had the gloss from Mr. Nam that it doesn't just have to be a legal right, it has to be an important legal right. And then Mr. Delowitz suggested in his submissions that it's relevant whether the association is invoking the legal right, as was the case in Lakeside, or the member. Apparently it's asymmetrical, that it's important.
And I don't want to put words in Mr. Gelowitz's mouth, but what I took from Matt was that really jurisdiction wasn't an issue before the court in Lakeside because it had effectively been conceded. That's how I understood it.
And that may be a different way of putting it.
That may be another one of my goofy interpretations.
No,
so
and I don't mean to suggest your interpretations are goofy, just that I disagree with them. To put it another way, according to the appellants, it doesn't matter how reasonable and clear the members' expectations about procedure were, it doesn't matter how violently and thoroughly those expectations were breached, and it doesn't matter how badly or extensively the decision has affected the member's life. If the appellant's argument is correct, then as a general proposition, a common law court has no power to do anything in relation to the procedural unfairness of which the member would complain. And that's so despite all of the case law to the contrary, not just Lakeside, but Lee and Showman's Guild and the cases that it cites, which go back to before the turn of the
Well,
century.
this is an interesting argument because I thought you told me we were relying on incremental precedent. The cases you cite might one day come before a court, but we are concerned with this particular case, and I think rhetorical statements about what might or might not, what a future court might or might not decide may not be all that helpful.
Sure.
Just a suggestion.
Absolutely. Let me then go straight to the argument put against the case law, and I will deal as part of that with what Lakeside says and what the UK Supreme Court held in Shergill. But what I want to say is, from a high-level perspective, the concern, Chief Justice, that I'm trying to highlight is the potential for serious harm at the hands of religious organizations, not because they're inherently harmful, not because they act maliciously, but because their scope of influence is so large. For many individuals, their religion is their lodestar. It tells them how to view the world and how to interact in it. It tells them what to eat, what not to eat, when to work, when to rest, what occupations to pursue, what occupations not to pursue. And it's that potential for harm that I say the court should have in mind as it thinks about how to calibrate this review. Should it be conditioned on the existence of a property or civil right? Should it be conditioned on the existence of an important property or civil right? Or should it just be available when the impact of the decision is significant?
But this is interesting. It's a harm principle, but there are many decisions that cause harm to people in everyday life that the courts would not get involved in. So I understand you're saying this is just part of the context. You should keep it in mind. You're not proposing it as a test.
I'm not proposing it as a test, but I ask you to think about it as we talk about this, because the contention of the appellants is that essentially religious organizations should be left all but alone. In only the most exceptional of circumstances should there be even this mild form of procedural review. And what I want to say is that goes too far. The form of procedural review
that I say Mr. Wall is seeking to invoke here is a relatively minor intrusion on freedom of religion.
I'm really interested in this, and you know my dissent in the Lakeside case. What bothered me in that case was how procedural review would really fit in with what was going on. Had they given Mr. Hoffer, I think it was, notice, had they done these things, would anything have been different? It didn't really go to the grievance. The real grievance was, I want to stay in the colony on my own terms, and my fellow brethren want me out. And that had been going on for a very long time. So you apply the legal rules of procedural fairness. You say you give notice, you give a hearing, you do these things. Where does it get you? And more precisely in your case, what does your client, Mr. Wall, think he will get out of procedural review in the legal sense? Can he make the courts make people bring their custom to him? I don't know. Would notice help, because he was obviously told in their own way that they had a problem, a difference of approach, that they thought he had a problem, more precisely, and there was a hearing of sorts. There was detailed meetings in accordance with the religious tenets, to which he submitted. He had an ample chance to tell his side of the story. And they said, just get over your problem, which is inconsistent with our ethics, and you're welcome back. So what is another layer of legal review going to do here?
Respectfully, Chief Justice, part of the problem is the narrative that you've just given is a narrative that's never been adjudicated upon by any court. There is a dispute about whether the notice was adequate. There is a dispute about whether he understood the procedure, the hearing to which he was being summoned, and the dynamics of it and his rights in it. There is a dispute about whether the committee was properly constituted, whether it was unbiased. And it may be that he has a very steep hill to climb on the merits. But that's actually part of my argument about why we should allow a hearing on the merits. Part of my argument, and one of the points that both you and Justice Gontier agreed upon in Lakeside Colony, is that the principles of natural justice are flexible. They're responsive to context. If the court has a concern about allowing procedural review in relation to religious organizations, I say respectfully that the answer is not to foreclose review altogether, but to ask, to instruct, to hold that it should be conducted with sensitivity to religious freedom, freedom of association, concerns about justiciability, and so on. All of that is legitimate.
Can I? Well, I was going to ask you if, in fact, the significance of the harm is the animating principle that should require a review based on process, on natural justice, why are you limiting it to natural justice? If the significance of the harm is what animates the review by the court, why wouldn't it go to the merits? What is, in your submission, the principle that would limit it to the merits? To the process and not the merits?
The case law and the fact that my client's originating application seeks a review only for process. And it's not a question of first impression.
But that doesn't help us in terms of looking at the coherence of these legal rules, what your client has asked for. So I'm just asking you to help me understand why, if I accept harm as the animating basis for judicial review of these, and I could say review broadly, then why wouldn't that mean I would have to look at the merits?
Well, because there might be countervailing considerations, Justice.
So what are they?
Well, for example, in the context of a religious organization, to review on the merits is to run head first into concerns about justiciability and the application of religious doctrine and potentially contested
religious custom.
Again, I just don't understand why what's justiciable would then drive limiting the court to process as opposed to merits. If it's not justiciable, it's not justiciable.
Right.
I'm just not making the connection between the principles you're asking us to use to accept your proposition and how those principles necessarily exclude review on the merits.
Because, and I think the answer, Justice Karakatsanis, is this court could look, as I'll show you in a moment, Lord Denning did, categorically, and say as a general proposition, as an almost universal proposition, to ask that a religious organization's decision be reviewed for correctness or reasonableness is to invite a justiciability problem. Therefore, we will prohibit it categorically and avoid the problem altogether. It is equally open to you, I suppose, to say, confront the problem on a case-by-case basis, and we won't foreclose it categorically. Sometimes we'll allow it. For purposes of this case today, or at least my client's success or failure in this case today, that doesn't have to be decided. But it is open to you to do it. It might be helpful, though, to turn, if you would please, to tab 6 of my condensed book, which is Lord Denning's decision in Lee and Showman's Guild. And in the first full paragraph at the top of the page, he says this. He says, the question in this case is, to what extent will the courts examine the decisions of domestic tribunals on points of law? So he's actually saying this case, Justice Karakatsanis, his case, is similar to the question you're asking me. When, if at all, should a court look at the substance of a domestic tribunal's decision? And he says this is a new question which is not to be solved by turning to the club cases. And then he says this, in the case of social clubs, the rules usually empower the committee to expel a member who, in their opinion, has been guilty of conduct detrimental to the club. And this is a matter of opinion and nothing else. The courts have no wish to sit on appeal from their decisions on such a matter any more than from the decisions of a family conference. They have nothing to do with social rights or social duties. Likewise, might be said that the courts generally have no wish to be involved in religious rights or religious duties. And that's at the center of my submission. But he goes on to say this, and this is the part on which I rely. On any expulsion, they will see that there is fair play. They will not involve themselves in the merits. They will, though, see that there is fair play. They will see that the man has notice of the charge and a reasonable opportunity of being heard. They will see that the committee observed the procedure laid down by the rules, but they will not otherwise interfere. And that's, for purposes of Mr. Wall's case, the law on which I rely. And I highlight for you that it isn't conditioned on the existence of some contingent property or civil right. It isn't conditioned on that contingent property or civil right being an important one. On any expulsion, the court will see that there is fair play.
Let's say, somebody is investigating, one of the interveners, the Church of Jesus Christ of Latter-day Saints, and they've been attending, and they've been taking the lessons, and they've been doing all the readings, and then they get a letter from the stake president one day saying, well, based on some information that we've received, we decided you're unworthy, and you will not be admitted as a member of the church. You'll not be permitted to take in the sacraments. Let's say this is in one of those communities that exist in Canada, which are predominantly populated by members of that church. So there's an economic hit. Where's the dividing line between exclusion and admission, or is there one in your view?
Well, I have three answers. The first is the question doesn't arise here. The second is
that doesn't interest me.
I understand.
We need a general
it interests
rule.
me, but I understand that you are considering other cases, and I want to be helpful to you in that regard. The second answer is the formulation of the right to procedural review that Mr. Wall proposes is one conditioned on a showing of sufficient importance. And it may be that an admission to a voluntary association, even in the circumstances you've described, will never rise to a level of sufficient importance. The third answer is this. The UK cases, including Shergill, premise this
jurisdiction for procedural review on the legal construct, the idea that the members have what they call a contract, what they're really describing as sort of a consensual constitution or agreement in the loose sense about how they're going to conduct themselves and the rules that will be followed. If that is indeed the legal construct that this court chooses to adopt, then it seems to me that that construct leads you to say someone who isn't yet privy to that arrangement, that consensus, that contract, cannot seek procedural review for a violation of it. There's a privity problem. I hope that's helpful.
Well, we often do, we always do say how, not always, often say how important it is for the person who is the target of the concern that has a right to explain, perhaps to say, look, I didn't do that, you know, you've got it wrong. And I suppose there is some merit in saying due process, natural justice, as opposed to give that person an opportunity either to say, I didn't do what I'm alleged to have done, or, yeah, I did, but there are extenuating circumstances. Members of the congregation, could you please take that into account in assessing whether this is a case for expulsion or not, as opposed to a situation where you just get, without any hearing whatsoever or any opportunity to state your piece, a notice that says you're out with no explanation, no nothing.
And that is the complaint here. The complaint by Mr. Wall, he may complain if he gets a rehearing by the Judicial Committee. First, if he gets an order for a rehearing and then the Judicial Committee chooses to hold one, he may argue that that they have misunderstood what he did, or they failed to consider extenuating circumstances, or they've misjudged his repentance, or they've misapplied religious doctrine concerning what sanction for his lack of repentance there should be. He may argue all those things, but his complaint right now, Justice Moldaver, is essentially the one you've described. He says, I didn't get proper notice. I didn't get a proper hearing. I didn't have a chance to make any of those arguments.
I thought he did, though. I thought he did have an opportunity to appear and speak to the elders and so on. I'm sorry, I may be wrong on that.
Well, whether he did or didn't is clearly in contention, and the problem is, because of the way this case has proceeded, i.e. on a threshold determination of jurisdiction, no court has ever heard him on that issue. There's a dispute in the evidence about whether he was or wasn't afforded procedural fairness. He says he wasn't. The Judicial Committee, not surprisingly, says he was. And all he wants to do is have his day in court so someone can decide whether he's right or they are.
But although there is no decision about, it is in the evidence, in the file, that there was a notice given, that there was an hearing to which Mr. Wall attended,
yes,
and that he was orally informed of the decision, and the ground of the decision was his insufficient repentance. The evidence shows that.
Well, sorry, I want to slow down, Justice Cote. Let's if we're going to talk about the evidence, I'd like to look at it, please. The notice is at the last page of tab 3 of my condensed book.
Okay.
This is the notice. Everybody agrees this is the notice. It says, Dear Brother Wall, we request your attendance to meet with the Judicial Committee, not to attend a hearing.
Tab 3?
I'm sorry, tab 3 of my condensed book, which looks like this.
Okay.
Last page.
Mm-hmm.
So he's requested to attend a meeting. In the next sentence, the alleged wrongdoing involves drunkenness. Not is drunkenness and only drunkenness. It involves drunkenness. We heard this morning about verbal abuse. It's not mentioned here. The meeting, not a hearing, will be held on Monday, March 24, 2014, 7 p.m. at the Harvest Hills Kingdom Hall complex. To reschedule for another time, please call Vaughn Lee. We look forward to providing you with whatever spiritual assistance we can. That's it. That's the notice. Now, it may be that when Mr. Wall, if he gets his day in court, a judge concludes that was good enough in all of the circumstances, given what had already happened or given what his expectations about procedure were. I don't
I don't wish to try to persuade you that he'll necessarily win. I don't have to get that far. I just have to tell you that he alleges that wasn't adequate. With respect to the reasons...
Sorry. Oh, I'm sorry. If you're still answering the question, I'll leave you.
If I may.
Of course.
With respect to the reasons, there is a dispute in the evidence about whether the reasons given by the committee were adequate. Mr. Wall's affidavit is at tab 2 of the condensed book. And I draw your attention, please, to paragraph 31, which is on the 3rd page. He says that on the above date, being March 24, the Judicial Committee did not state that I was unrepentant, nor explain why they may have felt that I was unrepentant, but instead simply said that I was to be disfellowshipped, publicly expelled from the congregation. Provision of an appeal was indicated. So according to him, he didn't get reasons at all.
Okay, that brings, I mean, I had the same kind of question that Justice Cote asked you. When I looked at the factum of the appellant, paragraphs 15 to 20 inclusive,
Justice Bella, sorry.
They set out all of the procedural entitlements they gave to Mr. Wall.
With reference to their own evidence and not his.
No, I know, but even, I mean, if you are right when you say there isn't a biblical way of looking at what natural justice means, did the person generally have the right to know what the case was against him or her and a chance to meet it? It seems to me that what you are asking us for is an even greater degree of procedural entitlement that might even occur in an informal administrative tribunal. Because he knows what the allegation was, he decided not to come to one meeting, he did go to another meeting, they gave reasons, they met for 3 hours, he's told of another meeting, he's told what he has to do in order to avoid the consequences of what their decision is, and then the conclusion is at paragraph 20. So I'm wondering whether, even on the highest standards of procedural fairness, assuming we can get past the jurisdictional argument, even under Shergill, I don't know how this wouldn't comply with what we have said is procedural natural justice in the ordinary courts.
If that evidence is accepted, in preference to Mr. Wall's contradictory evidence, there's a dispute in the evidence about the adequacy of the reasons he was given, about the extent of the notice. If a trial judge prefers the Judicial Committee's evidence to that of Mr. Wall, and if they adopt a relatively restrained conception of the requirements of natural justice, as they may well, then I agree with you. Mr. Wall will lose on the merits.
Was he told that he was to come to a meeting because he'd engaged in the sin of drunkenness? Is that in dispute?
Well, we just looked at the notice, Justice Bella. He was told to come to a meeting and the wrongdoing involved drunkenness.
Okay. And did he ask to present witnesses or not?
His evidence, their evidence is that he did not.
Did he confess to being drunk, as is said? I'm just trying to figure out what is not in dispute and what is in dispute. Are any of these facts set out in paragraph 15 to 20 in dispute?
Well, 15 is a argument.
16, sorry, 16 to 20.
There is no dispute, there may be a dispute about the date. He received a written invitation to meet with the Judicial Committee to respond to an allegation he had engaged in the sin of drunkenness. That is an interpretation of what the notice says, and it speaks for itself, and we've looked at it. The date of March 24 was proposed, but Mr. Wall was given the opportunity to reschedule for another time. True. The elders add, we look forward to providing you with whatever spiritual assistance we can. True. The member has opportunity to present witnesses to speak in his or her behalf. That may be true. There's no evidence that he was told it, which is his complaint. Mr. Wall did not ask to present witnesses. Might be true. May be beside the point if nobody bothered to tell him that was his right. When he met with the elders, he confessed to being drunk on 2 occasions, and on one of those occasions verbally abusing his wife.
Mr. Wall did not object to the meeting, the procedure, or any of the 4 elders participating. May be true, but in the absence of any, Mr. Wall's account of this meeting, a hearing, is that he was blindsided by it. The elders provide oral reasons for their decision. There is a dispute, clearly in the evidence. I just referred you to paragraph 31 of Mr. Wall's affidavit, where he says he didn't receive reasons. So there's a dispute there that has to be resolved by someone on the merits if we get there. But
Just trying to understand this. Are you saying because the church itself says we have certain rules that we accept and we adopt and we will apply in cases of this nature, that they cannot now come and say that they don't have to comply with any of that? They never have to. They could just tell the person that you're disfellowshipped, and that would be the end of it. Is your point that because they created their own mechanisms, then he's entitled to have them followed?
Yes.
As a matter of natural justice, due process, call it whatever you want. And his position is, much as they said these things, I didn't get them. Is that basically it?
yes, that is it. And it's consistent with Lord Denning's statement that the court will see that there's fair play. And
apparently there's some sort of right of appeal, so does he have to exhaust that before he turns to secular courts?
the case law says he does, and the fact is that he did.
Okay.
But just returning for a moment to these passages from the appellant's factum, the significance of them from my perspective is that they actually show that this is a rather pedestrian exercise that Mr. Wall is asking the court to engage in. As it may be an exercise in which the Judicial Committee is afforded great deference, in which the requirements of procedural fairness are minimal, in which everything is sort of scaled back in terms of its onerousness because of the context. All Mr. Wall is saying is, let me have my hearing. I may go in, it may last 60 minutes, and it may be that I'm thrown out and told, nope, that was procedurally fair enough, or I prefer the Judicial Committee's evidence to yours, you lose, you got adequate notice.
How should we answer that plea in cases, and in fact, your friends say this is one of those cases, where the process itself is religiously prescribed? I mean, my understanding is that the actual process here included prayer, presumably to achieve some sort of discernment. And it makes me wonder whether there is, in fact, a realistic line, as you posit, between procedure and substance. Your submission earlier was, well, you don't go to substance because that has a religious doctrinal dimension to it. But there are cases where the procedure will too. I mean, the Belgic Confession was mentioned earlier. Well, the Belgic Confession says that disciplinary processes will occur, by the word of God. So what do we do with that?
We do what Lakeside Colony counsels us to do, which is the best we can. We hear expert evidence about the custom, and we assess on an objective basis. Okay. It's what the case says, and it's what the Supreme Court of the United Kingdom says in Shergill. Maybe it's useful to turn to Shergill for a moment.
How do we review the discernment obtained in prayer?
Well, it may be, Justice Brown, that the solution to the problem you're proposing, and I agree, it's an obvious problem, is that we simply look to see whether there was prayer as prescribed by custom, and the question of whether the prayer was sufficient or insufficient, and whether the repentance...
We are going to decide if there was prayer according to a custom?
No, I'm sorry. I don't mean to suggest that we're going to describe whether the prayer itself conformed to the custom. We're just going to see whether the custom prescribed prayer, and if so, whether prayer occurred. I can't do better than to say that the court, as with any other case in which the court says there's something here to deal with, whether it be the obtaining of a religious divorce or ecclesiastical discipline, the court, once it's in there, it's going to do the best it can with the expert evidence that it receives about what the custom and tradition is. And it will not apply religious doctrine as such. There is no ability to sue to enforce
what one person perceives to be a religious edict and which another person disagrees to be that can't happen. But if there is a basis for being in court in the first place, and I say here is a common law right to procedural fairness, then the court does the best it can as it did in Lakeside. And I don't mean to suggest that it's necessarily easy. I don't mean to suggest that it isn't without its perils, but that's true of a lot of things. The courts across this country do things every day that are hard. They hear expert evidence to help them do that.
Can I take it that you're not arguing here today that the rules prescribed in the handbook, how procedure will be dealt with, that those do not create an implied contract? I haven't heard you talk about implied contract, and there are some written documentation about the process about conduct and the process that's to be followed.
Sure. The best I can do is this. The juridical basis for this procedural review, for the common law obligation to observe natural justice, is in Canada a bit unclear. The cases sometimes talk about contracts, sometimes they talk about property, sometimes they talk about a fundamental rule of law implicit in the realm. And my submission is that at this point it doesn't actually matter because it's water under the bridge. It's a bit like worrying about what was the juridical basis for the neighbor principle in Donahue and Stevenson. At this point, going back and looking at that is not going to help us very much in deciding what we should do in a negligence case today.
No, but it matters if it goes to the question of whether the court should be looking at it in the first place. And you gave us Shergill.
Yes.
In your factum, you talk about paragraphs 47 and 48 of Shergill.
Yes.
But paragraph 45, and I'm looking at your condensed book,
Yes.
says the courts address questions of religious belief and practice where its jurisdiction is invoked, either to enforce the contractual rights or if it's to deal with private rights and obligations. Shergill, in paragraph 59, again, I'm looking at your condensed book, was about a trust document and who was the beneficiary of a trust. It's a contract case. And what the court says in paragraph 59, if the parties can't resolve the differences, the court may have to adjudicate on matters of doctrine and practice to determine who the trustees are who are entitled to administer the trust. Now, that isn't a breach of what our understanding of when the courts have jurisdiction over religious matters is. It follows what we said in Lakeside. So I'm not sure what you read in Shergill that creates a standalone right to examine the conduct of unincorporated religious organizations to comply with what you say are common law entitlements in the absence of private rights and obligations or contractual rights. I mean, it's right there in 45. It's a trust document.
In a trust document is certainly sufficient, but Justice Avella, I'd like to draw the court's attention to paragraph 46. And I'm just going to read this because I think it's important. The law treats unincorporated religious communities as voluntary associations. It views the constitution of a voluntary religious association as a civil contract, as it does the contract of association of a secular body. The contract by which members agree to be bound on joining an association sets out the rights and duties of both the members and its governing organs. It doesn't say written contract, and there's no logical reason it would have to be a written contract. The courts will not adjudicate on the decisions of an association's governing bodies unless there is a question of infringement of a civil right or interest, not necessarily a legal right.
So you're saying there's a civil right interest, a freestanding common law civil right in all Canadians to have natural justice in every single circumstance.
No, I am not saying that.
Where then do they have it? If we can't tether it to something, then I don't know how we avoid scrutiny of everything in every circumstance.
Well, let's keep reading and maybe we can get an answer from Shergill. The court says an obvious example of such a civil interest is the loss of a remunerated office.
That's a contract.
Well,
Loss of a remunerated office is a contract of employment.
of course, yes, agreed.
Okay.
If I can, sorry, just forgive me. The governing bodies of a religious, I'm in paragraph 47. The governing bodies of a religious voluntary association obtain their powers over its members by contract. They must act within the powers conferred by the association's contractual constitution. Follow the rules. If a governing body of a religious community were to act ultra vires, for example, by seeking a union with another religious body which its constitution did not allow, a member of the community could invoke the jurisdiction of the courts to restrain an unlawful union. Not unlawful because it violates some other legal right, but because it's inconsistent with the rules of the association.
So does Mr. Wall have a contract with the congregation?
Well, in the British conception, he does, I say.
Does he? Okay, and what's the consideration that flows from him, and what's the consideration that flows back?
Right. There are two answers I can give to that, Justice Brown. One answer is that when we speak of a contract in this sense, we are not importing all of the requirements of the private law of contract, and it is it's just a term being used to refer to a...
So it's not doing any work?
I beg your pardon?
The term, it's not doing any work?
Well, I think it's shorthand for the consensual rules that define the association itself. And whether there's consideration given for them or not is I'm sure that I could devise an argument.
There's a circularity to that, because you're saying really the contract, the terms of this supposed contract simply govern how the contract is administered, but nobody has to really do anything beyond that. I mean, Mr. Wall is entitled to the contract being governed in certain ways, but there's nothing, I mean, there's a certain unreality to this contractual reference, because nobody's having to actually do anything under the contract except administer the contract according to the rules. There's no underlying obligation that you're pointing me to. What does Mr. Wall have to actually do under this contract? What does he get back other than, you know, a path to salvation? Or is that the consideration?
Well, the one obligation of Mr. Wall is to abide by the teachings of the Jehovah's Witnesses, in return for which he gets the continued fellowship of the fellow members of the congregation.
For as long as he wants?
For as long as he abides by the very same constitutional contract.
He can go to the court and say, make an order that they continue to fellowship with me? I mean, I know we're getting into substance there, but we have to take this thing to its end. If that's a contract, then he can go and ask for specific performance. It's not judicial review.
And Chief Justice, that is why it isn't a term that I would use to describe the constitutional consensus that governs and defines the organization, because I think it leads to a confusion in the sense that the case law doesn't support the idea that there's a claim for damages, for example.
Mr. Federt, earlier this morning, there was a reference to the fact that your client had launched an action in defamation for these events.
There was that. It's unknown to me, if so, but I don't have any basis.
Okay, you cannot comment on that, because I was about to ask you what was alleged in that.
I unfortunately don't have any additional light to shed. Okay. Before we leave Shergill, I'd ask, please, that we turn to paragraph 48, which is the paragraph which I most wish to rely. The court says this: similarly, members of a religious association who are dismissed or otherwise subjected to disciplinary procedure, which is precisely what has happened here, may invoke the jurisdiction of the civil courts if the association acts ultra vires or breaches in a fundamental way the rules of fair procedure. And that is not a new statement. That's not breaking new ground. That is just echoing what Lord Denning said in Lee and Showman's Guild about the need for fair play in the context of social clubs, and what the cases he cited had said before that.
So you don't see the beginning of the phrase as being the defining term, that is in the context of someone who's dismissed?
Dismissed or otherwise subjected to disciplinary procedure.
Right, exactly.
The appellants called this a disciplinary procedure. They are clearly disciplining Mr. Wall. Sorry, are we at cross purposes about what disciplinary procedure means?
I don't know if you're making an argument that says you don't need the contractual civil rights or property foundation because of this phrase in a fundamental way breaches the rules of fair procedure. If you are, all I was saying was I had read it as the rules of procedure in the case of people who are dismissed or otherwise disciplined from remunerated employment.
I didn't read it that way. And in terms of the need for a contract, my position remains that in the context of the UK cases, the contract is the association. They conceive of the association as existing by virtue of a compact by the members to come together and associate.
What do you say about paragraph 45, which frames the following discussion and sets out the limits, and we consider each circumstance in turn? So they're applying what they set out in 45 as their operative framework: private rights and obligations, contractual rights. They're just elaborating on what they said. They're not creating something new or deviating from it, are they?
Right, but what no, Justice Abella, there's no deviation. None of this is new law. But what I'm saying is that the contractual rights of the members are the right to associate with one another. The right, Justice Abella, if we look at the second sentence of paragraph 46, it, being the law, views the constitution of a voluntary religious association as a civil contract. That's the contract. We're going to come together and associate under certain conditions.
Contract. This would be a totally different case. Your client could sue for breach of contract.
And Chief Justice, I apologize because I feel as though I haven't been sufficiently clear. The contract is simply the legal or juridical conceptual justification for the rule that has existed in the case law for more than a century. And
If it's a false contract, what kind of conceptual justification does that provide?
Well, all right.
I mean, we're talking words here, and
Yeah.
lawyers are very good at spinning words. You're telling us that when the House of Lords used the word contract, they didn't know what they were saying. It was not really a contract, it's something else.
No, I don't mean to say that at all. I just mean that when they used the word contract, they were not importing the entire private law of contract, i.e. the right to sue for damages, or the right to seek specific performance, or a legislated requirement for witness, or that it be in writing, into all domestic tribunals and voluntary associations.
Well, then we'd have to define what the particular kind of contract that applies to a bridge club is.
Right.
And that would be a task for the courts to do in your submission. They would have to create a new kind of conception, which is not like the contracts that apply in commercial matters or other civil matters. So that's really the task you would be asking us to embark on if we accept this on your submission, that it's a special kind of contractual sort of thing.
Chief Justice, I think that's fair, except for the modifier new. I don't think that what I'm asking for in this case is new. I think that the court, if it's concerned with justifying it with reference to something other than the mere fact of precedent, there may be a new concept that has to be articulated. But I don't think the outcome, i.e. a right of procedural review, is new. That goes back to Lee and Showman's Guild and cases from the end of the 19th century.
You know, I guess we're going over ground that's already been tilled, but procedural review is grounded in a certain kind of concept, the rule of law, the control of government, state actors. Is that your concern? That's procedural review. Contractual review is grounded in something else, which is a covenant, et cetera. I won't go into all the details between the parties. So what you're relying on here is doctrine that uses the idea of a covenant, and I'll leave it at that, to give you procedural review. And that's where I'm having difficulty.
Right. And so maybe a different way of coming at it is to say that the law presumes, maybe it presumes irrebuttably, that people who associate with one another and give that association the power to make important decisions decisions that will profoundly affect their life. The law presumes that they have a reasonable expectation that fair procedure will be observed when those decisions are made.
I guess I'm having difficulty with, again, your emphasis on it's the power to make important decisions. And you're doing this, I think, because otherwise we would be dealing with any chess club, any kind of association where there's some set of rules that apply. So how do we draw the line? The Chief Justice asked this earlier. How does the court decide whether it has jurisdiction based on the importance of the impact of the decision?
Justice Karakatsanis, I say it can look to the prior cases. So let's just take two of the prior cases we've been talking about. Lee and Showman's Guild, Lakeside. Lee and Showman's Guild is the right to earn a living, to work, to perform in a particular place at a particular time. Lakeside, rather, is a case about the right to live on colony lands. The Hoffers were residing there. They wouldn't be able to reside there if their expulsion was valid. We can do as we do in the common law tradition. We can look to those cases and say, okay, Mr. Wall has come and he said, you ruined my life. My friends, my family, my customers, they will no longer speak with me. I'm ruined. And a judge, hearing the case on the merits, looks at this and says, is that good enough? After hearing the evidence, says, is that akin to the interest that was at stake in Lakeside or Lee, or is it a lesser interest? And that is what we do already in administrative law in deciding who has an interest, justifying notice and so on.
Thank you very much.
Thank you, Chief
Appreciate
Justice.
your submissions. We have reply.
Chief Justice, Justices, just 3 basic points in reply. First of all, I'll begin with the discussion of Shergill, and particularly the Court's focus on paragraph 46 in that decision. I'll just bring you back to that paragraph and point out a very important point in our submission. When it talks about the contract, it mentions at the second sentence after the colon, the contract by which members agree to be bound on joining an association sets out the rights and duties of both the members and its governing organ. So in British law, it talks about, first of all, in the first sentence or the second sentence, about a constitution and then an agreement. Members come together, they agree to be bound. It's a contract that where the intention is to be legally enforceable. And on that basis, the court could have jurisdiction. It's not because the governing body might have power to make important decisions. In some voluntary organizations like the golf club, where the question is your tee times and your access to the golf club, obviously the golf club is going to have rules that are going to divide that up, and there's going to be membership interests. They're going to have paid money to be able to have access to the golf club. They probably have rules because of that important interest. We're talking about a religious organization, and in Canada, a small voluntary organization.
Can you just tab 2 of your friend's compendium? Appended, it looks like, to the affidavit of Mr. Wall. Just help me out. What is this? Is this where I'm looking at sort of after the affidavit? There's something called preparing for a judicial hearing. And then there's another over the page, judicial hearing procedure, and then there's something about appeal hearing. Where does this come from? Are these the rules of the church?
This affidavit, Justice Moldaver, was provided by Mr. Wall as part of his originating application for judicial review.
Right.
And what he's attached were exhibits to that affidavit. He says that he found them on the internet. This is the direction given to the elders to help them, to assist them, to give them guidance.
Well, are the congregants aware of this and aware of the procedures that the church itself has put in place? I'm just trying to understand what's going on here.
The congregation is aware. There is When the as is brought out in the facts of the case and is in our factum, before a member joins the congregation, before they're baptized, they go through a process of 80 questions that they answer. They're given a handbook of the organization which points out the procedures, the generous religious practices of the organization. So they understand that that handbook contains the idea of a judicial committee, a hearing before a judicial committee, and the whole procedure is simply to help the sinner understand this is serious. You have to, like, you just can't chew gum in church. This is not that kind of problem. We're talking about a serious moral problem where the elders have to intervene.
Does the congregant have a right to expect that if in fact he or she is being looked at for some error that they committed or sin that they committed, and where the possibility of disfellowship is being considered, do they have the right to expect that these rules, these principles, whatever they are, will be followed by the church? That's a simple question. I mean,
And the simple answer, Justice Moldaver, is absolutely. Absolutely. Not out of contract.
Pardon?
Not out of contract. Absolutely out of religious obligation.
So if they're not followed, it doesn't matter, because I'm just trying to, again, understand this. You create certain rules that allows congregants to come forward and give their side of the story and so forth, so on and so forth. But if they're not followed, too bad. The courts cannot interfere, and that's the nature of it, because the only issue at stake is your membership. Is that the idea?
That is, Justice Moldaver, as extreme as you put it, that is the position. Because the process is religious. To look at it is invidious interference with religious belief.
So you don't agree with Lord Denning, what Lord Denning said, or do you?
Lord Denning, in reference to social clubs?
Well, yeah, but I mean, following the rules of the club, that they've got to do that.
If the rules are of the level of a contract, yes. And I just would add, I would point out, Justice Moldaver, when Lord Denning, referred to social clubs, and he refers to a case of Antibus from 1880, we're talking about English social clubs where there were property rights. They were actually buildings, homes where people went for meals. They had a membership right to those. Those are the social clubs that are being described. And there was contracts. What we have here with regards to the Highwood congregation is, Mr. Feder used the word compact. The Australian High Court added to that expression. They referred to a voluntary consensual compact. And they said that there's no intention to create legal relationships. And that's exactly what this is, this situation. They're coming together out of religious fellowship and worship with no intention to create legal relationships. So yes, the congregation does have its internal religious procedure, and there is religious obligation on the congregation to follow that procedure, but not a legal obligation. That's a matter of religion, not legal rights. And the court can concern itself with legal rights, but not religious obligation. And I would point out, importantly, with regard to Shergill, that case was decided without any reference to the European Convention of Human Rights and not under the Charter in Canada. The second point in reply is Mr. Feder said all that Mr. Wall wants is his day in court. That really this is quite a pedestrian case. He points, for example, to the notice that Mr. Wall received, and he says, so the court's going to look at this document. The court's going to hold it up to examination and say, did you give, is this appropriate reference, invitation or not? Was it clear enough? Maybe, maybe not. That's invidious interference with religious belief. They did this out of religious belief, not out of any contractual obligation. There's no rules of court for the congregation because it's not a court. They're inviting him to a pastoral meeting. As they said, we want to give you spiritual assistance. They really don't want to disfellowship him. They want to reconcile him to God. That's why there's the 3 or 4 elders present, and they're using the Bible, they're praying, and they're meeting with him to bring him to spiritual repentance, not just fellowship. And that would be the sad outcome for everybody, Mr. Wall, and for the congregation, and for the elders. So to say now, and then we're going to look at, well, what did they tell you? What was the oral reasons they gave? Did they tell you that it was repentance or what? Once again, we're examining religion. It's that invidious interference that's spoken of in Amsterdam. It's that whole idea of Big M Drug Mart and tyranny of the majority, where the majority looks and says, okay, well, from my majoritarian religious viewpoint or from my secular viewpoint as a judge, I don't think it's enough. You really didn't understand or couldn't expect what you walked into. It's a religious process. And the members understand the religious process, because that's part of how they self-define. They come together, they understand this is what we want to belong to, and if they don't want to belong to it, they can walk away.
Are there any limits to that, in your view? If you collide with certain core values in the way a church functions, regardless of property or contractual rights, is there a remedy, in your view?
As the interveners pointed out, Madam Justice Abella, it's the ability to leave, to start your own religion. If you as a member say, I no longer share the core values of my other religious compatriots, members of the same congregation, I can either try within to get you to agree with my beliefs, and failing that, it's to leave and start your own religion, start your own congregation. Perhaps your beliefs will resonate with others within the congregation. The resolution is not go to court and ask the court to be the coercive effort on the congregation to get them to change their religious beliefs, to be more conforming to some ideal. Just one final point. Counsel for Mr. Wall said that the interest has to be substantial because religion will do terrible things. Frankly, that's offensive. The Highwood congregation is not trying to cloak what it does and say you can't go there, it's impossible to look at, we can do terrible things and the court can do nothing about it. Not at all. The position of the appellants, the position of Highwood Congregation of Jehovah's Witnesses is the court can intervene. The de minimis standard for intervention is civil rights, property rights. And of course, there's always the alternative to the criminal law. If the elders beat Mr. Wall up during that meeting, that would be repugnant to the ideas of Jehovah's Witnesses. But if that were to happen, we're not saying, well, it was done in a religious meeting, you can't go to the criminal court. Absolutely, he could go to the criminal court.
But falling short of criminal behavior.
But falling short of
Mr. Wall talked about his daughter being shunned and the effect on his family. You say that there's no relief available in those circumstances except to walk away from the church.
The de minimis standard is property and civil rights, which would include tort. So if there's some kind of tort that's occurred, that's obviously something that a person could bring to court, like a defamation action, or intentional infliction of mental suffering. Those are actions that are possible. If it went to that legal harm that a court could assess. Absolutely, the congregation is not trying to hide itself under religion from civil consequences of its actions. It's not saying it can do whatever it wishes under the cloak of religion. It is simply saying we want to be able to determine who our members are according to our religious beliefs, and no more. That's all that we ask the court not to become involved in. That the court has already decided that in Amsterdam, that those religious obligations, tenets of religious belief, religious doctrine, are not justiciable. And the procedure used by the congregation to determine membership or to exclude someone from membership is religious. Substance is process, process is substance. Thank you.
Thank you all. Merci beaucoup. The court will reserve its decision, and the court stands adjourned.